At 2 p.m. if possible.
2 p.m.
At 2 p.m.
Not this Friday. You'll have it on first.
That's for Friday.
1st of March, Friday.
No, next Friday. It is too late. We cancel. Subject is also
Next Friday, not possible. You'll have it on 1st of March, so we can give you on Monday. Pick your date.
Monday.
Next Monday.
Thank you.
Please change your date.
No.
Yes.
Wait, please, Lord. Lord, my victim mention item number 28.
20?
8.
28.
I am for the petitioner, my lord.
Yes, okay.
My
At the joint request, matter stands adjourned. At the request of MS Sutia, Learned Council for
Some reports,
PWD might.
PW.
some reports were called for, my lord. They have not
Matter stands adjourned for 2 weeks. Mr. Kolita, Learned Council appears for the petition. It is not
May I
a
pray for a date, my lord? Because my petitioner is ill, my lord. Her husband already died.
11th March.
All right.
Yes.
Look, on the last occasion, my learned friend was making his argument. His argument was not concluded. Basically, I have covered everything, only I need to sum up.
Sum up on it. I believe, my lord, he will give a reply.
Give a reply.
Summing up is also over.
When I sum up in
A reply
by
which
giving the
will-
reply, I'll
Which
sum
will amount to a sum up.
Of the whole thing,
Yes, yes.
my lord. My lord, I have gone through the petition, my lord. One very important aspect I have to present before your lordship is this, my lord. This writ appeal is, this writ petition is basically challenging the OM of 18/1/2023, which your lordship will find at page 107.
Yes. You are giving your reply in WPC 363.
Well, I'm giving basically reply in all the petitions for the state respondents. And I'm defending the OM of 18/1/2023, which in this first petition, my lord, your lordship will find at page 107.
Yes.
Lordship will kindly take note of the date. This was issued, this OM was issued on 18/1/2023. And the OM itself in the very first paragraph says that it is pursuant to the judgment passed in the Bhagwan Patar, which was this. Lordship will just have a look at page 107, madam. Page 107.
Yes.
In the very first paragraph of this OM, Lordship will find the Honorable Guwahati High Court in his judgment and order dated so and so 6/6/2022 in WPC number so and so, Bhagwan Patar versus SOA and another 5026 of 2016 Equality Forum at para so and so of the order has observed that so and so. Now, next paragraph, the government of Assam, after careful examination of the Honorable Guwahati High Court judgment dated so and so in WPC number so and so, has reviewed the existing procedure and effecting reservations in promotion with consequential seniority for the reserved categories, and accordingly lays down the following guidelines to be followed while considering promotion in any establishment. This OM is under challenge. In fact, the entire OM is not under challenge. They are challenging the paragraph Roman 4.
Yes.
Which provides for the consequential seniority. It deals with consequential seniority, but it provides for catch-up theory and not the consequential seniority. Yes, paragraph 3 also. Now, clause 3 of that OM. Now, Lordship may kindly have a look at this very important aspect which I have to highlight, my lord.
Yes.
I'm just pointing on one particular paragraph of this. Hello, this when this writ petition was filed, the two writ petitions which were disposed of and mentioned in this OM of at page 107 were disposed of and with certain observations and directions pursuant to which this OM was issued. Those two judgments were taken on appeal and those were pending at the time when the writ petition was filed. Am I clear, my lord? The two writ petitions were filed, disposed of, and certain liberty was granted. Taking that liberty, which is mentioned in page 107 of the OM, this OM was issued. Then this OM was put to challenge in this writ petition. But simultaneously, at the time when this writ petition was filed, those judgment, common judgment in those two writ petitions were already challenged in a writ appeal. And the writ appeal was pending, which my learned friend in the writ petition is mentioned at para 20. Lordship may kindly have a look at para 20 at page 24.
Yes, please.
Para 20, I am reading, my lord. The petitioner begs to state, while the aforesaid judgment passed in Bhagwan Patar versus State of Assam was holding the field, personally kindly note the words, holding the field, similar other tagged up matter came up for hearing before other coordinate benches and the same are awaiting final disposal judgment. On the other hand, an appeal has been preferred against the judgment dated 6/6/2022, passed in connected writ petition being WPC number 5026 of 2016, before the division bench of this honorable court being writ appeal number 239 of 2022, being Equality Forum versus State of Assam. While on the other hand, two leave to appeal applications has been filed before the honorable division bench of the Guwahati High Court being Sanjal Mahanta versus Bhagwan Patar, filing number so-and-so, along with so-and-so, and IV Guhai Dasgupta versus Bhagwan Patar, etc., wherein notices have been issued and the matters are pending adjudication. It is pertinent to mention herein that in neither of the aforesaid cases, stay order has been granted against the operation of the judgment dated so-and-so, passed in writ petition number so-and-so, and Bhagwan Patar case number so-and-so. And my submission before Lordship is, while the petitioner is aware that pursuant to the judgment passed in the single bench, if nothing happens, position remains same and it holds the field as he has mentioned here. And when it holds the field, the OM was issued and the OM is put to challenge in the context of the observations and directions issued by this honorable court in the two writ petitions matter.
According to him, it holds the fields in his favor.
Yes, absolutely, madam. Now, when this writ appeal was disposed of, observations and conclusions in respect of the consequential seniority with which we are concerned, madam, in this case, have been reversed, which I will show from the appellate judgment, madam, in the writ appeal. In that view of the matter, my first submission before Lordship will be this writ petition is not maintainable today. And Lordship may kindly have a look at because what has happened is, in the writ appeal, my lord, there are two paragraphs. The second paragraph, which I am relying, my lord, is paragraph 45. There, the observations are absolutely in consonance with the two clauses of the OM of 2016, which they put to challenge. And their challenge was upheld by the honorable single judge, but then reversed by the division bench in the writ appeal. In that view of the matter, unless this writ appellate judgment is put to challenge and, my lord, disturbed, the present writ petition will not be maintainable at all. This is my submission, madam. I'm just reading that paragraph 45 of that judgment, madam. Your lordship is having a copy, madam.
Yes, yes.
A reading of clause 4, my lord, clause 4 of that 2016, which was the subject matter of challenge in the writ petition.
You may like to read from a few paragraphs before that.
Of this judgment, my lord.
This
Yes,
judgment.
absolutely, absolutely. If you lordship desire, I can read the whole judgment, my lord, from the beginning.
Maybe from para 32 or something.
Or 37.
No, you can read from 32. 32.
32, yes. Yes. We have taken note that the recommendation of the one-man commission referred in OM dated 29/12/2014 had in the meantime been held to be unacceptable as per the judgment of this court in Equality Forum, Supra. At this stage, we take note that in fact there are two judgments available both in respect of petitions instituted by the Society Equality Forum. One such is the judgment dated 23/12/2015 rendered in WPC number so-and-so and so-and-so, reported in so-and-so, and the other is the judgment and ordered so-and-so in WPC number so-and-so and so-and-so. For clarity and convenience, we refer the judgment rendered in Equality Forum, reported in so-and-so, to be Equality Forum 1, and the judgment dated so-and-so in WPC number so-and-so and so-and-so to be Equality Forum 2. In other words, the purport of OM dated 29/12/2014 has to be understood that it was issued consequent upon the amendment to the Act of 1978. As noted above by the Assam Act of 19 of 2012, the Act of 1978 had been amended by which Section 5A thereof had been introduced. It had also been taken note herein above that Section 5A of the Act 1978 provides for post-based roster for implementing the reservation in promotion. And as the office memorandum dated 29/12/2014 had been issued consequent upon the amendment by which Section 5A of the Act of 1978 had been introduced, the word roster in clause 1.11 and the further provision that the roster do not intend to determine seniority would have to be understood in the context of Section 5A. All that Section 5A of the Act 1978 provides is that earlier the reservation in promotion was given effect by following the procedure of vacancies, but upon introduction of Section 5A, the same would be done by following the roster point in the roster scale. If a reservation in promotion is given effect or implemented based upon the roster point in the roster scale, there is always a possibility that a reserve category candidate may be promoted against the post which may be a little higher up in the roster scale, as the said roster point post may have fallen vacant. In that circumstance, provision of 1.11 would have to be understood that the seniority referred therein related to the roster would mean that if a reserve category candidate is promoted against a roster post which would be a little higher in the roster scale in the comparison to the other promotees who may be a little lower in the roster scale, the same will not entail any seniority over the others who were also promoted in the same process but placed perhaps a little lower in the roster scale. In other words, placement of the reserve category candidate in a given roster point, irrespective of the position, would not determine the seniority of such candidates, and the seniority would be determined otherwise under the law, depending on the manner and circumstance in which promotion was given effect. It being the meaning of the provision of clause 1.11, it must be understood that clause 1.11 of the office memorandum dated 29/12/2014 does not relate to any consequential seniority of a reserve category candidate. In the context of meaning attributed to clause 1.11 in the manner indicated above, when we read the provision of clause 14 of the office memorandum dated 29/12/2014, it is noticed that the said clause provides that all existing orders on the subject are deemed to have been amended to the extent as provided in the office memorandum. The expression are deemed to have been amended to the extent herein above would mean that it also includes the extent as provided in clause 1.11, meaning thereby that the aspect of determination of seniority provided therein is not related to any consequential seniority, but it relates to a provision that by following the roster point system, if a reserve category candidate is promoted in a post which is otherwise a little higher in the roster scale, it being positioned in the higher in the roster scale will not determine the seniority of that person over others who may be promoted against a post in the roster scale which may be a little lower. Accordingly, it would have to be concluded that conjoint reading of clause 1.11 and clause 14 of the office memorandum dated 29/12/2014 would mean that consequential seniority that was otherwise meted by the office memorandum dated 12/3/2002 had not been withdrawn. With regard to the contention of Mr. So-and-so and senior counsel for the petitioner in writ appeal number 239 of 2022, we take note that as per paragraph 47 of the judgment dated 23/12/2015 in Equality Forum 1, Supra, there is an express prohibition by a judicial pronouncement that till such quantifiable data on backwardness, inadequacy of representation, and inefficiency in administration is collected, no reservation in promotion in favor of reserve category candidates can be further carried forward. But paragraph 74 of the judgment dated 23/12/2015 In Equality Forum 1, Supra provides for collection of quantifiable data in respect of backwardness of the reserve category candidates, as well as inadequacy of their representation, which again would have to be determined cadre-wise and service-wise in the respective departments. And further, upon such data being obtained, there would be a requirement of harmonization with the efficiency in administration as provided under Article 335 of the Constitution of India. But the requirement of the provisions in the judgment dated 23/12/2015 in Equality Forum 1 would again have to be read in the context of submissions of Mr. Swensol and Counsel for the unreserved category candidates that in paragraph 36 of Journal Singh 1, Supra, there is a presumption in law in favor of backwardness of the reserved category candidates. And in view of such presumption in law, there is no further requirement of obtaining any quantifiable data to substantiate the backwardness. The said provision being rendered by a constitutional judgment of the Supreme Court, when read together with provisions of judgment in Equality Forum 1, it has to be understood that there would be no further requirement under the law for any collection of quantifiable data to substantiate the backwardness of the reserved category candidates, inasmuch as there is a presumption in law as regards the existence of backwardness. Further, we also have to take note that in paragraph 47 of the judgment of Honorable Supreme Court in Journal Singh 2, it has been provided that the adequacy or inadequacy of representation of reserved category candidates would have to be determined cadre-wise, service-wise, and in a given relevant department. The said provision is also consistent with the provisions in paragraph 74 of the judgment dated 23/12/2015 in Equality Forum 1 that the collection of quantifiable data regarding adequacy or inadequacy of representation would have to be determined cadre-wise, service-wise, and department-wise. If the determination of quantifiable data is for adequacy or inadequacy of representation of the reserved category candidates in a given cadre of a service in a particular department of the government, we are in agreement with the contentions raised by Mr. Das and counsel for the respondents, the Bhagwan Patar, that it would be more prudent and appropriate to undertake such exercise through the departmental promotion committee itself before embarking upon a promotion process for a given cadre. In say the same would be prudent in as much as the DPC will have all the data before it as to the cadre strength of the promoted cadre, where the promotion is to be considered, and out of the total cadre strength, how many posts in the cadre are to be earmarked for the reserved category candidates, and out of the earmarked reserved category posts, how many posts are being occupied by reserved category candidates. In other words, if the reserved category candidates are occupying all the posts earmarked for the reserved category candidates in a given cadre, it can be easily understood that in that given cadre, there is an adequacy of representation and the reserved category candidates, and in the event the number of reserved category candidates in the cadre is less than the number of posts earmarked for the reserved category candidates, it has to be understood that there is an inadequacy of representation in that given cadre. If the determination will be made in the above manner, we are of the view that it will be more appropriate and apposite for the DPC to make such determination. But again, such determination would have to be made before initiating the actual promotional process. As regards the third requirement, obtaining quantifiable data, it should also harmonize with the inefficiency in administration. We take note of the provisions of judgment of the Honorable Supreme Court in BK Pavitra 2, wherein in paragraph 126, it has been provided that inefficiency in administration referred to in Article 335 cannot be construed on the basis of a stereotypical assumption that roster point promotees drawn from the scheduled caste and scheduled tribe communities are not efficient, or that efficiency is reduced by appointing them. And secondly, the provisions in paragraph 116 of the said judgment, wherein by referring to the Constituent Assembly debates in respect of the position expressed by Muhammad Ismail Khan, no citizen shall be discriminated on account of religion or race, meaning thereby that an interpretation is sought to be given that if across the board the reserved category candidates are construed to be inefficient or contributing to the inefficiency in the administration without specific factual determination, it would be a discrimination on account of race, which would be impermissible under Article 15 of the Constitution of India. As a determination of the quantifiable data on the inefficiency in administration across the board in respect of reserved category candidates would amount to a discrimination on account of race, which is prohibited under Article 15 of the Constitution of India. We also have to hold that the requirement of obtaining quantifiable data on efficiency of administration because of the reservation in promotion meted to the reserved category candidates would also be a violation of Article 15 of the Constitution of India and hence impermissible. As the three contentions raised by Mr. Chaudhary, learned senior counsel for the petitioner in writ appeal number so are answered as indicated above, meaning thereby that as per the judgment of the Honorable Supreme Court in paragraph 36 in the journal Singh, there is no requirement of obtaining quantifiable data as regards backwardness, and as per the judgment rendered by the Honorable Supreme Court in paragraph 116 and 126 of B.K. Pavitra, quantifiable data on efficiency and administration across the board in respect of the reserve category candidates cannot be obtained, and further, as a quantifiable data in respect of adequacy or inadequacy of the representation of the reserve category candidate can also be done at the level of DPC in respect of the cadre for which the promotion process had been initiated. We are of the view that prohibition imposed by paragraph 47 in judgment dated 23/12/2017 in Equality Forum 1 would have to be understood in the manner indicated. In other words, as there would not be any requirement of obtaining quantifiable data on backwardness and inefficiency in administration, and obtaining the data regarding adequacy or inadequacy of the representation can be done at the level of DPC, the prohibition imposed by paragraph 47 in the Equality Forum would no longer hold good, subject to the condition that DPC, before embarking upon each and every promotion process, undertakes an exercise to determine the adequacy or inadequacy of representation of the reserve category candidates in that particular given cadre where promotion is thought to be made. Now, as regards interpretation of clause 4, we are concerned with clause 4 in this case. Of the office memorandum dated 3/8/2016, we again quote the said provisions, which is as below. If an occasion arises during the promotion process in which stipulated percentage in respect of reserve category is met, but in the gradation list, seniority list, there are candidates of reserve category who on merit is entitled to the promotion, her case shall be considered for promotion on merit if such candidate has not gained the seniority by way of any accelerated promotion earlier. Now, this is important, para 45. A reading of clause 4 makes it discernible that if an occasion arises during the promotion process in which stipulated percentage in respect of reserve category is met, but in the gradation list, there are candidates of reserve category candidates who on merit are also entitled to a promotion, his or her cases are to be considered for promotion on merit only if such candidate has not given seniority by way of accelerated promotion. What should we kindly say? It would mean that if a reserve category candidate is seeking for a promotion against any post in the promoted cadre, which is earmarked for a reserve category candidate, he would be entitled to the benefits of consequential seniority as provided in the office memorandum dated 12/3/2002. But on the other hand, if the posts earmarked for the reserve category candidates are already exhausted by being occupied by the reserve category candidates, but in the gradation list there remains some further reserve category candidates, they can compete for promotion against unreserved posts, but in such an event, they would not be entitled to the benefits under the consequential seniority. And on the other hand, if on the basis of their seniority otherwise, that is without taking note of the consequential seniority, they are within the zone of consideration, such candidates will be considered for promotion. So, my lord, this is totally in consonance with clause 4 of the 2016 OM, which was put to challenge in the writ petition. And this has been reversed in this writ appeal. I am just taking a lordship for the purpose of, my lord, examining as to whether this is in consonance with the 2016 OM or not, which was put to challenge by them. Lord, will kindly turn to page 63 of the writ petition, madam. My lord, this is the OM which was challenged by them, my lord, in the writ petition. This is 3rd August 2016. Lordship has got, my lord.
Yes,
Now,
clause 4.
yes, clause 4, which you lot will find at page 65. If an occasion arises during the promotion process in which stipulated percentage in the respective reserve category is met, but in the gradation list, seniority list, there are candidates of reserve category who on merit is entitled to the promotion, his or her case shall be considered for promotion on merit if such candidate has not gained the seniority by way of an accelerated promotion earlier. So when the seniority which he gains by way of accelerated promotion plus the consequential seniority, because accelerated promotion followed by catch-up theory means he goes down. Person belonging to a general category, my lord, after his promotion to the higher rank, he gains his seniority. This is the catch-up theory. So the catch-up theory has been upheld by the division bench. Now here again, when the OM of 2023 has been issued, my lord, which your lot will find at page 107.
One zero seven.
107.
Yes.
I'm reading now this. I need to read this whole OM, my lord. The very first paragraph, my lord, that paragraph 7, Roman 9 has been quoted from the judgment of the single judge. Thereafter, it is provided like this, my lord. The government of Assam, after careful examination of the Honorable High Court judgment, etc., has reviewed the existing procedure of effecting reservation in promotion with consequential seniority for the reserve categories and accordingly lays down following guidelines to be followed while considering promotion in any establishment. Number 1, policy of reservation in promotion shall continue. So this policy of reservation as such is not under challenge because they belong to reserve category. They want that there should be a policy of reservation in promotion. Roman 2, my lord. Each establishment while taking up the process of promotion in a particular cadre of a service shall examine the representation of SC, STP and STH candidates in the cadre in comparison with the prescribed percentage of reservation and calculate shortfall, if any, in the cadre with reference to that particular year. Shortfall of reservation of a particular reserve category in cadre means difference between the total number of reserve posts for that category in the cadre and the number of persons of that category holding the post in the cadre. While calculating the shortfall, all candidates belonging to the same category, SC, SC, STP or STH, shall be taken into account irrespective of the mode of entry into the cadre, that is, whether on account of seniority cum merit or merit cum seniority as the case may be, or through any other process admissible in law or by way of reservation. If in a particular cadre SCs and STs are not adequately represented and shortfall is found to exist in the cadre, it may be considered as inadequacy in representation insofar as that particular cadre is concerned. Such shortfall shall be filled up by concerned category of incumbents within the zone of consideration either on account of seniority cum merit or merit cum seniority or by way of providing reservation as the case may be till the prescribed percentage in the respect of the said category is achieved. There is no quarrel with this particular clause, my lord. Next, if no eligible incumbent belonging to the shortfall category is available within the zone of consideration, this will further substantiate the status of backwardness and inadequate representation of the category in the cadre, and therefore the number of posts that are required to meet the calculated shortfall shall be kept vacant, and vacancy shall be carried forward and filled up in the next year. In case the sufficient number of SC or STP or STH candidates fit for promotion against reserve posts are not available, and if the post cannot be allowed to remain vacant on grounds of maintaining efficiency administration, the appointing authority may, with full justification, refer the vacancy to the Department of Personnel for de-reservation, subject to the condition that no eligible candidate belonging to the category for which the post is reserved is available within the zone of consideration placed before the Annual Selection Committee, DPC, for 2 consecutive years. In other words, the concerned departments may move proposal for reservation in the 3rd year. So, this clause is very clear. If eligible qualified candidates are not available for 2 consecutive years from the reserve category, then they will move the proposal for de-reservation of that post. 4th is important. In case of promotion in Group A services, the quantum of reservation for SC, STP, STH in promotion shall be as per stipulated percentage of reservation available for these categories. However, SC or STP or STH government servants in Group A services on their accelerated promotion by virtue of rule of reservation shall not be entitled to consequential seniority. The application of general catch-up rule will allow eligible officers who were senior in the merit list at the entry level in Group A services to regain their seniority in the promotional post once they are promoted to the same cadre as an officer of reserve category, provided the officer of the reserve category had got his promotion ahead of an officer senior to him in the merit list by way of accelerated promotion on account of reservation in promotion in a particular cadre. Seniority of government servants in Group A services shall be revised, Lord will kindly see, accordingly as per above principle. Further, an officer promoted from Group B to Group A service will also regain his seniority in Group A service on promotion vis-a-vis his compatriot in Group B services, provided that an officer was senior to the reserve category officer in the particular Group B cadre prior to the promotion of the reserve category officer in Group A. Seniority of such Group B government servants promoted to Group A service shall be revised accordingly in Group A. If an occasion arises during the promotion process in Group A service, in which stipulated percentage in reserve category, this is important, is met in the next promotional grade, but in the zone of consideration, there are candidates of reserve category who on merit are entitled to the promotions. Their cases shall be considered for promotion on merit if such candidates have not made into zone of consideration by way of any accelerated promotion earlier by virtue of rule of reservation. I know this is language is slightly changed, but it is just perimeteria with the clause 4 of 3816. This has been in clear terms in paragraph 45 of the appellate judgment, my lord, upheld. Now your whole writ petition is based on the premise that honorable single judge has upheld the consequential seniority. Now when the consequential seniority has been done away with and catch-up theory has been upheld by the appellate judgment, unless you challenge that your writ petition is not maintainable, and that too, my lord, when the writ petition, they themselves say that when we have filed the petition, there was no disturbance with the proposition laid on by the honorable single judge. Now there is a change. You have said that there is no stay, there is nothing, so it is holding the field. Now it is no longer holding the field. You have not amended the petition. In the present form, my lord, writ petition is not maintainable. My lord, it is ex facie, my lord, staring at the face. They are absolutely, my lord, clear. While filing the writ petition, they were, yes, at the time when they filed the writ petition and the OM of 18/1/2023, bringing in the catch-up theory was issued, the judgment passed by the honorable single judge in those two writ petitions, my lord, was holding the field. Now, during the pendency of the present writ petition challenging the OM of 18/1/2023, when though the appeals filed against the single judge judgment
Yes.
were disposed of in such a way that the consequential seniority concept has been done away with. My lord, in Nagaraja's, I'm just referring for a moment one particular paragraph of this Nagara judgment. I'll get back to my oral submission again, my lord. I'm just saying, para 79 of this M. Nagaraja,
Yes.
I think that judgment is already available before Lord. Para 79.
So, Yes.
Lordship has got my lord.
Para.
Para 79 at page 259, my lord.
Yes.
I'm reading, my lord.
Yes.
Reading the above judgments, we are of the view that the concept of catch-up rule and consequential seniority are judicially evolved concepts to control the extent of reservation. The source of these concepts is in service jurisprudence. These concepts cannot be elevated to the status of an axiomatic like secularism, constitutional sovereignty, etc., as has been argued on behalf of the petitioner in this case, my lord. It cannot be said that by insertion of concept of consequential seniority, the structure of Article 16.1 stands destroyed or abrogated. It cannot be said that equality code under Article 14, 15, and 16 is violated by deletion of the catch-up theory rule. These concepts are based on practices. However, such practices cannot be elevated to the status of a constitutional principle so as to be beyond the amending power of Parliament. Principles of service jurisprudence are different from constitutional limitations. Therefore, in our view, neither the catch-up rule nor the concept of consequential seniority is implicit in clause 1 of and 4 of Article 16 as correctly held in Virpal Singh Chauhan. Well, what I am actually trying to impress upon your lordship is that the either catch-up theory or consequential seniority, these concepts are, since judicially evolved concepts to control the extent of reservation, it depends on the policy of the government.
Yes.
One cannot say that the constitution itself, as has been argued by repeated, this is why I am pointing out. You cannot say that Constitution Article 16 was amended first in 1977th Amendment and then 85th Amendment. 85th Amendment is the amendment by virtue of which, my lord, the Parliament has enabled the state, also the central government, to provide for consequential seniority. And since it is an enabling provision, and since it's a matter of policy, it is up to the government whether they go for this consequential seniority or not. But at the same time, my lord, the Supreme Court has made it very clear in Paneer Silvan and B.K. Pavitra. I'll refer to the relevant paragraphs, my lord, that if the government doesn't take any policy about any of these two concepts, my lord, which are relevant for the purpose of determination of seniority alone, it has got nothing to do with reservation in, or policy of reservation in promotion. These are only for the purpose of determination of seniority. And that too, in the event there is a policy of reservation promotion. If there is no policy of reservation promotion, it's not necessary at all. When the government is having a policy of reservation, then the next question comes whether the government will go with the concept of catch-up theory or consequential seniority. But if the government doesn't say anything, Paneer Silvan is very clear, my lord, then it is a catch-up theory which has to be understood to be prevailing. But if it is catch-up consequential seniority, the government has to collect quantifiable data, government has to take a policy decision and express it by issuing an appropriate executive order. Hmm.
So consequential seniority has to be specifically
Yes, my
mentioned.
lord. For catch-up theory, it is not required. If the government is totally silent about the determination of theory, determination of seniority, and the theory relevant for that, then it has to be understood that catch-up theory is prevailing. It is this, I am making this submission I am making, my lord, because it is the catch-up theory rule has been for the first time propounded by the Honorable Supreme Court in that Virpal Singh Chauhan's case, my lord.
Yes.
Now, I'm just referring to one particular small paragraph of S. Paneer Silvan, my lord, which is reported in 2015 10 SSC page 292, paragraph 26. Lordship, my lord, these judgments are already there before your lordship. That is why, my lord, I have not again. Paneer Silvan, your lordship has got, my lord.
Yes, yes.
2015
There are
10
so
SSC.
many paper books and judgments.
My lord, my lord.
We need to,
In fact, I think if it is paper, there should be an index. My lord. I don't know who has provided the paper.
no, no, they have provided their judgments. Doesn't matter.
My
We
lord.
have it. Yes,
My lord.
paragraph.
Para 26, my lord.
Yes.
Page 308.
Yes.
The true legislative intent under Article 16(4)(a) of the Constitution is to enable the state to make provision for or frame rules giving consequential seniority for the accelerated promotion gained based on the rule of reservation. May I read it again?
No, it's okay. I
Yeah.
read it.
Rule 12 evidently doesn't provide for consequential seniority for reserve category promotees at any point of time. This we are not concerned. The consequential seniority for such reserve category promotees can be fixed only if there is express, as your lordship has just now said, madam, express provision for such reserve category promotees in the state rules. Madam, there at one point of time an argument was made by referring to the
Yes.
amendment made in our Assam Act of 1978, that post-based roster, that in section 5A, the concept of consequential seniority is implicit. My submission is this is absolutely incorrect. Post-based roster introduced in the Assam Act by way of an amendment pursuant to the judgment in R.K. Sabharwal has got nothing to do with the concept of determination of seniority. These two are absolutely two different things, madam. There is absolutely no connection. Now, my next sentence. In the absence of any specific provision or policy decision, madam, this is important, taken by the state government for consequential seniority for reserve category, accelerated promotees, there is no question of automatic application of Article 16(4)(a) of the Constitution. This is just contrary to the argument made on behalf of the petitioner that 85th Amendment of the Constitution, by which 16(4)(a) was brought in the concept of consequential seniority, and any rule, any decision, any act done by the state against the theory of consequential seniority will be unconstitutional. This runs contrary, this particular paragraph runs contrary to that particular argument. Consequential seniority is not something which is automatic. Government has to exercise its power, and the enabling power is 16(4)(a) to decide, to take a policy decision as to whether there will be a consequential seniority or not. In our case, my lord, there was, my humble submission before lordship is, there was absolutely no necessity to say anything about the catch-up theory in the OM of 18(1)2023, but
That by implication means it is there.
it is there. So by words, expressed words, we are making it clear that we are going with the catch-up theory, but there is some modification here and there. That is why the language. Otherwise, if nothing is provided, it is, since it is not automatic, it is the catch-up theory which will prevail.
Yes.
Next, your lordship will kindly have a look at the paragraph of, my lord, my lord, this is 2020 volume 11 SEC page 399. That is, my lord, that famous judgment by Honorable Justice D.Y. Chandrachud, Sudhakar Babu Rao Nangudi. I think his copy is available here.
Yes,
My-
yes.
I'm just referring to para 47 once, my lord.
Yes. Forty-seven.
My lord.
Yes.
Since
Reference
it is the
to
latest one.
Selvam.
Yes. Now here this para 26, which I have just now, para 26 of my lord Paneer Silvan has been quoted.
Yes.
And then lordship will kindly turn to para 48.
Yes.
Here, my lord, para 29 of B.K. Pavitra's judgment has been quoted, which I would like to just read, madam. It is clear from the above discussion in S. Paneer Silvan state of Tamil Nadu that exercise for determining inadequacy of representation, backwardness, and overall efficiency is a must for exercise of power under Article 16(4)(a). Mere fact that there is no proportionate representation in promotional posts for population of SC and ST is not by itself enough to grant consequential seniority to promotees who are otherwise junior and thereby denying seniority to those who are given promotion later on account of reservation policy. It is for the state to place material on record that there was compelling necessity for exercise of such power, and decision of the state was based on material, including the study that overall efficiency is not compromised. In the present case, no such exercise has been undertaken. The High Court erroneously observed that it was for the petitioners to plead and prove that overall efficiency was adversely affected by giving consequential seniority to junior persons who got promotion on account of reservation. Plea that persons promoted at the same time were allowed to retain their seniority in the lower cadre is untenable and ignores the fact that a senior person may be promoted later and not at the same time on account of roster point reservation. Depriving him of his seniority affects his further chances of promotion. Further plea that seniority was not fundamental right is equally without any merit in the present context. Now, this is important. In the absence of exercise under Article 16(4)(a), it is the catch-up rule which fully applies. It is not necessary to go into the question whether the corporation concerned had adopted the rule of consequential seniority.
Yes.
My lord, what I am trying to impress upon your lordship is, my lord, when in the OM, particularly that particular clause of the OM which is under challenge before your lordship, my lord, provides that we are not with the consequent seniority. Now you challenged it, as I have argued, my lord, initially. You challenged it at a time where the single judge judgment was prevailing. There, of course, certain observations are there in favor of the consequent seniority, because the observation was in this way, my lord, that 2002, when the OM was issued, my lord, giving a go by to the 1996 policy of catch-up theory, it prevails till today, even after 2016. This was the ultimate, my lord, analysis and observation. Now, in that very judgment, my lord, if your lordship just goes to the one particular paragraph,
Which judgment?
my lord, the single judge judgment, yes. Page 105 of the writ petition, my lord. the Bhavan Patra's judgment by Honorable Single Judge,
Yes.
starting from page 66, page 105, my lord, what will find. While upholding the theory of consequential seniority, my lord, has made an observation in paragraph 7, Roman 9, at page 105. It provides like this, my lord. Article 16.4a and 16.4b being enabling provisions, the state is at liberty to implement its policy of giving reservation in promotion with consequential seniority, at liberty to provide for reservation in promotion without consequential seniority, or at liberty not to provide any reservation in promotion. Now, the impugned order at page 107, Lords will find it is this liberty which has been, my lord, utilized by the state. Page 107, Lords, you may kindly have a look, my lord. This para Roman 7:9 of Bhagwan Patra's judgment has been referred here, and it is because of that particular liberty that this OM has been issued on 18/1/2023. In the first paragraph, my lord, down below, the entire paragraph Roman 7:1, Roman 9 of 7, paragraph 7 has been quoted. Now,
And what is your view with regard to the division bench
my lord,
judgment
My lord.
regarding this particular
yes,
aspect?
my lord, the liberty has been, my submission is very simple and clear, my lord. Liberty has been given by the honorable single judge.
Liberty is already there post
No, liberty,
Nagaraj.
absolutely, my lord. Liberty is there.
So
Your lordship is
it
absolutely
has
correct.
only reiterated what is
Absolutely, my lord.
whatever
Absolutely.
is
Your
there.
lordship is absolutely. Liberty is already there.
Already
Since
there.
the provision itself is an enabling provision, liberty is always there.
always there.
It is a question of policy which the government takes. If you say that no, the policy decision taken by the government is
No,
bad,
no, no. The query which I have
My lord.
asked
My
is in view of your submission
my lord,
little while ago that division bench has reversed the findings of the single bench. Is
Yeah.
that's your submission? isn't it?
yes, yes.
So
My lord, what has happened is
hmm,
two things are there. In this single, I'm replying to your lordship's query, my lord. Your lordship's query possibly is when in the single bench judgment there is one paragraph upholding the consequential seniority, and at the same time in the subsequent paragraph liberty has been granted. Now, what will be the position of these two observations vis-a-vis the present OM?
what is the finding of the division bench? Any specific finding with regard
Yes.
to
Para 45, Lords will kindly say once again. Tonight. Now,
para 45?
Yeah. It will.
Yes.
Para 45. May I read it slowly again, man? Para 45. I've read it, I'm reading it again, man. A reading of clause 4 makes it discernible that if an occasion arises during the promotion process in which stipulated percentage in respect of the reserve category is met, but in the gradation list, seniority list, there are candidates of reserve category candidates who, on merit, are also entitled to a promotion. His or her cases are to be considered for promotion on merit only if such candidate has not been given seniority by way of any accelerated promotion. It would mean that if a reserve category candidate is seeking for a promotion against any post in the promoted cadre which is earmarked for a reserve category candidate, he would be entitled to the benefits of consequential seniority as provided in the OM of 12/3/2002. But on the other hand, if the posts earmarked for the reserve category candidates are already exhausted by being occupied by a reserve category candidate, but in the gradation list there remains some further reserved category candidates, they can compete for promotion against the unreserved posts, but in such event, they would not be entitled to the benefits under the consequential seniority. And on the other hand, if on the basis of their seniority base, otherwise and that is without taking note of the consequential seniority, they are within the zone of consideration, such candidates can be considered for promotion. Language is absolutely clear. And in fact,
Read with para 46.
yes, para 46. Yes, fine. Para 46. Upon issues being raised in present appeals having been decided in the manner indicated above, it is further provided that the decisions rendered in the present judgment in the table number so and so and so and so and so would prevail over all such provisions of the learned single judge in the judgment it is so and so in this Pator's case matter. But in respect of any other provisions which may not be contrary to or inconsistent with the provisions of the judgment, the same may prevail. But with a further clarification that if any such provisions of the judgment of the learned single judge is in conflict or contrary to any of the provisions in the present judgment, such provisions in judgment of the learned single judge stands modified accordingly. So this paragraph 45 is absolutely clear. It is not only in consonance with para Roman 4 of the 2016 OM, but also separately, my lord, with separate sentences, independent of that OM, it has been clarified that if you have gained your status in a particular seniority list by virtue of operation of the theory of consequential seniority, you will not be considered, you will not come within the zone of consideration for the purpose of your consideration for promotion to a post which is not reserved. It's absolutely clear. Now, in the face of this observation by the division bench, my lord, my submission is, my lord, the present writ petition is not maintainable.
Okay.
It's crystal clear, my lord. And that too, my lord, in a case where in the writ petition you have said that the single judge's judgment has not been disturbed, it is holding the field. Now, during the pendency of this writ petition, my lord, the situation has changed, and in the changed circumstances, the single judge's judgment is not holding the field. What happens to your writ petition now, my lord? It's no longer holding the field, and this has been clarified in para 46 of the judgment. And my learned friend, while arguing this petition, he has not referred to these two paragraphs. What will be his stand now after the division bench judgment has come?
Yes.
So that being the position, my lord, in the present form of the writ petitions, this OM of 18/1/2013, 2023, first of all, has not been challenged, keeping in view the observations of the Honorable Division Bench. And secondly, my lord, they are only relying on certain paragraphs of Nagaraj and all. But here in the present case, the situation is completely different. We are concerned with the policy of the Assam government. Assam government policy has undergone various changes through the judgments of passed by some court from Equality Forum 1. So in that way, the matter, my submission before lordship is the writ petition may be dismissed in limine. Madam.
What about section 5 of the Act? Would you like
Well,
to?
I have made it clear. I'm just reading it once again. Just
Back it up.
Well, in order to, well, if your lordship permits, well, I'll read section 5. Let me see section 5. The 5 or 5A, my lord?
This is
5 is the
78.
well,
78
78.
Act.
5 is the extent of reservation in
What?
favor of the different
I
categories.
think it
of
will be 5A.
5A, my lord, yes.
Yes. Five A.
5A is immediately, my lord, post R.K. Sabharwal. So I'll refer to one or two paragraphs of R.K. Sabharwal to understand the object for which the 5A was inserted in the Assam Act, my lord.
Yes. Yes.
And I'm reading the provisions. The reservation for the members of the scheduled caste and scheduled tribe in services or posts in an establishment shall be given effect to in the following manner, namely, a post-based roster register shall be maintained to give effect to the reservation of vacancies for SC and ST. Such roster shall be based on the model roster as per Schedule 1 and 2 appended to this Act and shall be adopted for the purpose by which each establishment in this such manner that the prescribed percentage of reservation is maintained in each cadre. Each appointing authority shall prepare and notify the roster based on the principles laid down in this Act and maintain roster registered in a manner containing such number of posts as are equivalent to the number of posts in a cadre. In case any increase or decrease in the cadre strength, the roster shall correspondingly by expanded or contracted. 3. The roster is to be operated on the principle of replacement and not as a running account. In other words, the points at which reservation for different categories applies are fixed as per the roster and vacancies caused by retirement, etc. of persons occupying such those points shall be filled up by appointment of persons of the respective categories. Separate rosters are to be maintained for giving effect to reservation in direct recruitment and promotion. Then remaining Roman 5 and 6 we can skip, my lord. 7, Lordship may kindly see. Appointments of candidates belonging to SC and ST which were made on merit and not due to reservation are not to be counted towards reservations so far as direct recruitment is concerned. In other words, they are to be treated as a general category candidates. So this way, my lord,
No. What the purpose is, does it anywhere implicitly indicate consequential seniority?
no, man, that's what my
That is what we want you to.
my lord, in order to understand this section insertion, purpose of insertion section 5A is
It is
the
only
RK Tower one.
it is only for identifying the posts of reservation, maintaining a registrar.
Yes, slot. My lord, what happens, my lord? In RK Sabharwal's judgment in the railway case, my lord, the argument was that since the persons belonging to scheduled caste and scheduled tribe are already there, so their numbers are met, their percentage is met. The reply of the Honorable Supreme Court was that no, unless they belong to the reserve category
Yes.
and they are appointed through the reserve category, my lord, even if their number is more, the percentage cannot be held to be met. First. And secondly, it is the replacement theory. Reason is, my lord, supposing the person, I'm giving an example, my lord. Supposing the percentage for ST is 7%. And the 7% has to be, which refers to be the cadre strength. If the cadre strength is 100, 7 of the entire 100 vacancies, my lord, will have to be filled up by ST. Am I clear, my lord? Now, if it is not post-based roster, but vacancy-based, each time 10 vacancies arise, 7% will be inducted, then they will exceed 7%, my lord. If 5 times, my lord, or 10 times, or 10 vacancies are, my lord, advertised, and every time 7% is to be given, then they will exceed their limit. That is why it is a replacement. A person holding a particular reserve category post, if he retires, a person belonging to the same category will have to be promoted so as to fill up that post. This is the post-based roster theory, my lord. It has got nothing to do with the consequentiality or catch-up theory. Indirectly, it may come, as my learned friend is arguing, that if the post reserved for reserve category persons are not appointed, the post remains vacant, and post-based roster is not followed. This is what my learned friend is trying to argue.
Here I like to object. Well, on 2 occasions, while I argued on 3 dates, well, it can be checked up from the live streaming.
Yeah.
He was not present. I never made those submissions.
All right.
From
right.
where he
All
got,
right.
only he knows.
No, you'll get your.
Yes,
Yeah,
okay. That I'll have to point out.
Yes.
He was not present when I'm.
My submission is very clear and simple. Post-based roster theory inducted in the Assam Act by virtue of this 2013 amendment after the 2012 amendment after the RK Sabharwal has got nothing to do with the concept of catch-up theory or consequentiality as introduced by the Virpal Singh Chauhan in 1995 and subsequently, my lord, there has been evolution further. Absolutely no connection, my lord.
Yes.
My lord, relying on this section 5A, my lord, my purpose is what? Relying on section 5A of the Assam Act, they are trying to challenge the OM of 18-1-2023 when there is no connection at all. So my submissions, my lord, the provisions of, my lord, section 5A of the 1978 Act do not in any way curtail the power of the government to provide for either catch-up theory or consequential seniority in the matter of determination of seniority if there is a policy of reservation in promotion prevailing in the state. That is my submission, my lord.
Thank you.
Oh, yeah. এখন দিয়ক না
Yes.
My lord,
You have brought a written submission.
no, what I have done, my lord, I have tried to summarize
No, that's very helpful.
from the very beginning,
Yes.
78 Act. I'll just read 3-4 paragraphs. Then my learned friend has covered almost everything, but I'll just supplement 2-3 parts.
I'm just taking liberty, my lord. I have completed my part, my lord. So in the second half, I have some difficulty, my lord. So I have completed my.
Now, if your lordship would kindly come to para 2, my lord.
Yes.
That before, I'm just, my projections which I'm making, my lord, that I would like to read it out. That before adverting to the projections made by the petitioner in the writ petition, the answering respondent would like to put the facts and legal position with regard to accelerated promotion and consequential seniority in perspective. As far as state of Assam is concerned, the state legislature enacted the Assam Scheduled Caste and Scheduled Tribe Reservation of Post-10 Services Act 1978 to provide for reservation in favor of Scheduled Caste and Scheduled Tribes in matters of direct recruitment and promotion. Subsequently, via OM dated 3693, Government of Assam was pleased to extend benefit of reservation in direct recruitment to OBC MOBC. Section 5 of the Act of 1978 provided for reservation in favor of Scheduled Caste and Scheduled Tribe in matters of promotion, which benefit was, however, not extended to OBC and MOBC. Another important aspect which needs to be highlighted is that under the Act of 1978, the rosters used to be filled up on the basis of vacancy, a practice which has been deprecated by the Honorable Supreme Court in R.K. Sabarwal, wherein Apex Court held that the cadre strength is always measured by number of posts comprising the cadre. Right to be considered for appointment can only be claimed in respect of a post in a cadre. As a consequence, the percentage of reservation has to be worked out in relation to the number of posts which form the cadre strength. The concept of vacancy has no relevance in operating the percentage of reservation. That in the meantime, law relating to reservation received a different interpretation in M. Nagraj. The Apex Court, while upholding the validity of Article 16.4a, 16.4b held that impugn constitutional amendments are enabling in nature, and the amendments left it to the states to provide for reservation in promotion. It was observed that if appropriate government enacts a law providing reservation without keeping in mind the parameters of Article 16.4 and 335, then court will certainly set aside and strike down such legislation. The Apex Court at para 119 of the report also held that concept of reservation in Article 16.4 is hedged by 3 constitutional requirements, namely backwardness of a class, inadequacy of representation in public employment of that class, and overall efficiency of administration. Thus, at para 123, the Apex Court held that state concern is not bound to make reservation for SC/ST in matters from promotion. If the state concerned decides to provide for reservation in matters of promotion, in as much as in such an event, the state will have to show in each case the existence of compelling reasons, namely backwardness, inadequacy of representation, and overall efficiency of administration. Thus, the state of Assam, having regard to the observation of the apex court in R.K. Sabharwal, amended the Act of 78 by Act number 19 of 12, wherein Section 5A, the matter of procedure for giving effect to reservation has been prescribed. Section 5A3 provides that roster is to be operated on the principle of replacement and not as a running account. Under the Amendment Act of 19 of 12, the earlier vacancy-based roster available under 78 Act was replaced by a post-based roster. That in the judgment dated 6/6/22 rendered in Bhagavan Das, that single judges, the learned single judge dealt with two aspects: whether there is a requirement of collection of data with regard to inadequacy of representation, as mentioned in Article 16.4, and overall efficiency of administration, as envisaged in 35. The other aspect was whether in the state of Assam, the benefit of consequential seniority extended to roster promotees by OM dated 12/3/2002 is still available. In the present list, the later issue arises for consideration. What is significant to notice from the judgment in Nagraj is that Article 16.4a and 4b have been held to be enabling in nature, and state is not bound to make reservation for scheduled caste and scheduled tribe in matters of promotion, much less consequential seniority. It is for the state concerned to make such a provision, and if state decides to make a provision, then it is imperative for the state to collect data with regard to inadequacy of representation and overall administrative efficiency. From constitutional scheme and case laws, it is not possible to discern that consequential seniority is automatic, inasmuch as state concerned will have to make provision not only for reservation in promotion, the state concerned shall also have to make provision for consequential seniority. That pursuant to the decision of the apex court in Virpal Singh Chauhan, state of Assam was pleased to issue OM detail 12/6/96, whereby it was provided that a general candidate will regain his seniority over the roster promotee who earned his promotion earlier by virtue of roster promotion. In other words, OM introduced catch-up principle in the matter of fixation of seniority. That consequent upon amendment of Article 16.4a, the state of Assam issued OM dated 12/3/02, which inter alia provided that SC/ST government servants shall under promotion by virtue of rule of reservation be entitled to consequential seniority also, with effect from 17/6/95. That is very important. That when OM dated 12/3/2002 was issued by the state government, the legal position which emerged post Nagraj that Article 16.4 is an enabling provision and that state is not bound to make reservation in promotion was not settled. Under the circumstances, state proceeded as if there is a mandate to provide consequential seniority also to roster promotees. It was on the aforesaid premise that OM dated 12/3/02 was issued and operated. That consequent upon amendment of Assam Act of 78 by 2012, Government of Assam issued OM dated 29/12/14, which inter alia provided for preparation of roster. Clause 1.11 of the said OM dated 29/12/14 provides that rosters are in aid to determine the entitlement of different categories with regard to quota reserved for them in matters of appointment. They are not intended to determine seniority in the cadre. Clause 14 of the said OM provides that all other orders on the subject are deemed to have been amended to the extent herein. This 20 argument based on 29/12/14 was not accepted by learned single judge as well as by division bench. Let me make it very clear, my lord. Though it is very clear, it says rosters are meant only for identifying the slots. It has got nothing to do with determining seniority. Anyway, my lord, division bench has otherwise in terms of 3/8/16 has given us relief. I'll place that. That pursuant to the judgment dated 23/12/15 of the Honorable High Court in WPC number so-and-so, wherein it was held that if state desired to give effect to reservation in promotion, it would have to justify the same with the help of quantifiable data. The Government of Assam issued OM dated 3/8/16, after reviewing the existing procedure of effecting reservation in promotion. Clause 4 of the said OM provides as follows. If an occasion arises during promotion process in which stipulated percentage in respect of reserve category is met, but in the gradation list, seniority list, there are candidates of reserve category who on merit is entitled to promotion, his or her case shall be considered for promotion on merit if such candidate has not gained seniority by of accelerated promotion earlier. Thus, it will be noticed that after issuance of OM dated 12/3/2002, which conferred benefit of consequential seniority to roster promotees, various changes has taken place in the legal scenario as explained herein above. By necessary implication, if not expressly, roster promotee is not entitled to consequential seniority with effect from 29/12/14 and subsequent dates. Now, following issuance of OM dated 18/1/23, though Government of Assam has decided to pursue the policy of reservation in promotion in all posts, but in respect of a group as services, it has been decided that roster promotees on their accelerated promotion shall not be entitled to consequential seniority. In other words, OM dated 18/1/23 recognizes right of unreserved candidate to regain seniority in the promoted cadre by application of catch-up principle. That in the circumstances, a pertinent question arises for consideration in the present list, whether OM dated 12/3/2002 lost its efficacy with effect from 29/12/14 when Government of Assam, pursuant to decision in so-and-so, amended the Act of so-and-so, wherein it was specifically provided rosters are not intended to determine seniority in the promoted cadre. Even assuming while not admitting that OM dated 29/12/14 did not expressly repeal OM dated 12/3/2002, but by necessary implication, it can certainly be asserted that OM dated 29/12/14 was issued to override OM dated 12/3/2002. Further, issuance of OM dated 3/8/16 referred to above sets at rest the above controversy. Now, I'll just read one more paragraph, then I'll make my submission. It is a well-settled principle of law that there is a presumption against an implied repeal, but this presumption will stand rebutted if provisions of the new OM, that is 29/12/14 and 3/8/16, are so inconsistent with the old one, that is 12/3/02, that the two cannot stand together. And in the judgment, Honorable Supreme Court has said, by necessary implication, the OM dated 12/3/2002 stands repealed. What follows from the above is that catch-up principle evolved by the apex court revived with effect from 29/12/14 until 17/1/23 by necessary implication and expressly with effect from 18/1/23. So these are the factual and legal parameters. Now I have put it in writing just to trace the history of how our, my lord, reservation law has evolved. Now, my lord, what is the basic case of the petitioner? If your lordship would remember, my lord, what my learned friend would like to contend is, by virtue of the constitutional amendment, there is a constitutional mandate which overrules all the earlier judgments of the Supreme Court. Therefore, accelerated promotion and consequential seniority is an automatic, relief which the reserve category candidates are entitled to. Now, my lord, here let us be very clear about on facts. They are heavily banking on the learned single judge's judgment, the Bhagavan Patters. My lord, I'll first draw your lordship's attention to that judgment, one paragraph. Single judge Bhagavan Patters. Space. My lord will have that judgment.
We have it.
If your lordship is holding the petition, please, Kiman.
66 to 10.
66, my lord.
866.
Yes. If your lordship will kindly come to page 40 of the internal of the judgment.
Page
40 internal of the judgment.
40, yes.
Roman 9 paragraph.
Yes.
Now, my learned friend is fully with the learned single judge's judgment. He has no, reasons to, agree by the observation. Please come to Roman 9. Article 16(4)(a) and 16(4)(b) being enabling provision, the state is at liberty to implement its policy of giving reservation in promotion with consequential seniority, at liberty to provide for reservation in promotion without consequential seniority, at liberty not to provide any reservation in promotion. So while disposing this batch of writ petitions, my lord, the learned single judge was clearly of the view, and rightly, that Article 16(4)(a) and 16(4)(b) are enabling provision, and in that view of the matter, it is open to the state to have a reservation policy as it desires. And the policy could be, my lord, only reservation in promotion, no accelerated seniority, or the policy could be no reservation in promotion, no, therefore, there is no question of consequential seniority. Now, keeping this in mind, now Lordship will kindly examine the matter. Now, my lord, my learned friend Majumdar has already placed section 5A, which is very important in this case. That's why I've indicated in my written argument also. Now it operates by way of a replacement. It operates by way of replacement. That means they're entitled to their slots only. That is why, my lord, they cannot participate with general category candidate in a post which are, because their earlier accession to the position in the feeder cadre was by virtue of accelerated seniority, not by virtue of merit. Otherwise, my lord, they're all junior. By virtue of roster only, they got the accelerated promotion. Now, why, my lord, either be it clause 4 of 3816 or 18(1)(23), why this view has been taken by the government? And that this view is supported by the Supreme Court judgment. That I'll place, my lord. Please have 1996 2 SCC 715. Ajit Singh's case, my lord, Ajit Singh 2. 1996 2 SCC 715.
You carry on, we'll find out the judgment. Yes. Read the relevant paragraphs.
Para 9, my lord. Judgment was
1996.
1996 2 SCC 715. Why, my lord, a reserved category
Sorry,
candidate,
Para?
para 9.
Para 9.
Why, my lord, a promotee who has the advantage of accelerated promotion, why he cannot be given a consequential seniority? That is the rationale. Once the quota is full, hey, judgment to 9 is very important. That's what we do. That extra copy I can must be there, my lord.
इसमें देखो
It is there, my lord.
Yes.
My lord will kindly come to page 29, para 9.
Yes.
Once the quota is full and roster has stopped for members of the scheduled caste and backward classes, in respect of whom reservation has been made and roster has been prescribed, then their case for promotion to a still higher grade against a general category post has to be considered, not treating them as members of the scheduled caste and or backward class on any crux. They cannot be promoted only on the basis of their accelerated seniority against a general category post. In Sabharwal, it was said that the candidate belonging to scheduled caste who compete on their own merit along with the general candidate, then they are not to be counted within the percent of reservation made for such candidates in service because they have competed with the general category candidates on their own merit. If they make on their own merit, then there is no bar. This same principle which has been enunciated by the Constitution bench in the aforesaid case shall be applicable whenever a member of scheduled caste or backward class has got accelerated promotion to a higher grade and is to be considered for further promotion to a still higher grade against the general category post. Thus, the accelerated promotion are to be made only against posts reserved or roster prescribed. There is no question of that benefit being available when member of a scheduled caste or backward class claims promotion against general category post in the higher post. In the, my lord, promoted cadre, if there is a slot for reserve category, then that seniority will be available as division bench says in para 45. Same view. It needs hardly be pointed out that such candidates who are members of scheduled caste or backward class and have got promotion on the basis of reservation and application of roster before their seniors in the lower grade belonging to general category in this process have not been superseded, first because there was no inter se competition of merit between them. So it's not a case of supersession. As such, when such seniors who belong to general category are promoted later, it cannot be said that they have been superseded by such members of scheduled caste or backward class who have been promoted earlier. While considering them for further promotion against general category post, if only fact that they have been promoted earlier, being member of scheduled caste or backward class is taken into consideration, then it shall violate the equality clause and the view and against the view expressed not only in R.K. Sabharwal by Constitution bench, but also by 9 judges bench in the case of Indra Soni, where it has been held that in any case the reservation should not exceed beyond 50%. So, my lord, this is the underlying reason.
Yes.
In other words, my lord, clause 4 of OM dated 3886 and the provision in 18.123 to the extent that a reserved category candidate who earns promotion by virtue of roster, he cannot be considered for further promotion against a general category post. But if there is a reserved category post in the promoted cadre, for that seniority can be utilized only for, my lord, filling up that post. That is why it is said it is only by way of replacement. Earlier it was a running account. Until and unless the quota is filled, my lord, the account is to run. Now it is by replacement. Therefore, my lord, whole idea is you as a reserved category candidate, when you earn an accelerated promotion, then in the meantime, if a general category candidate, even if he earns the promotion subsequently, he regains his seniority. As has been rightly pointed out by my learned friend, Mr. Majumdar, my lord, if the law is silent, then there cannot be any presumption that accelerated seniority will be automatic by virtue of Article 16(4)(a) and 4(b). What would be the consequence? Then if it is silent, then, my lord, catch-up principle will revive. To that extent, my learned friend has already placed the decision of Paneer Silvam, my lord, which I am also placing. He has already read it. I'll just give this citation, my lord. That is 2015. 2015, 10 SCC 292. My lord, para 36. I think the first judgment on the compilation, my lord. Kindly just one small paragraph, my lord. Para 36. The first judgment of the compilation.
Yes.
At page number 312. Para 36.
Yes.
In the absence of any provision for consequential seniority in rules, the catch-up rule will be applicable and roster point reserve category promotee cannot count their seniority in the promoted cadre from the date of their promotion, and the senior general candidate, if later reach the promotional level, general candidate will regain their seniority. The division bench, now this is the same argument of my learned friend. The division bench appear to have proceeded on an erroneous footing that Article 16(4) of the Constitution automatically gives consequential seniority in addition to accelerated promotion to the roster point promotees, and the judgment of the division bench cannot be sustained. In fact, my lord, the learned single judge in Bhagavan Patar also held the same view, which is absolutely wrong, my lord. It is wrong. It's not automatic. It has to be conferred. It has to be given.
Which
So, my
has,
lord, I have shown
which has
to-
been now interfered with by the appellate
Yes.
judgment.
Yes. Now, my lord, the Mukesh Kumar case I'd like to place where the reserved category, they do not have any right. Supposing government decides one way or the other, then they cannot say, my lord, how this benefit must be given to us. My lord, 2020, 3 SCC page 1. I'll have your lordship's kind attention to paragraph 18, my lord.
Yes.
2023 SCC page 1.
Yes. This is for the proposition.
This is for the proposition, my lord. There is no vested right in any reserved category candidate to claim either reservation in promotion or, my lord, accelerated consequential seniority. It all depends upon the policy of the government. If the government pursues a particular policy, that is good enough. A reserved category, he cannot come to the court and demand that no, there has to be a policy.
There is a division bench
Okay,
which we are required to sit when DB1 rises.
my matter only.
Your matter, yes. So we have been informed that
Go to court number 1
we
now.
can all go to court number 1. We are informed that it will be at 12. So we'll continue after
Yes, no problem.
the DV. We come back
Yes.
from the DV. So essentially,
It'll take another 15-20 minutes, not more than that.
another 15 minutes.
15.
Okay, I thought another 2 minutes we could have. Anyway, we'll come back.
Yes. Batate down there, huh?
Whatever dates will be there, it will be there. You don't worry about it.
Yes,
You will fix a date. You give it to the court.
lordship, lordship.
May it please your lord.
Now, I don't know who is responsible, but it is definitely appears to be the effect of the arguments.
Pator, the Pator effect.
Huh?
Pator effect.
Bhagavan Patar.
Our name is also divine.
Yes.
I think, my lord, time has come to remove all this, subject to what your lordship may say. I don't think there
No,
should be any
see,
barrier between
There
us.
was no difficulty for
Ah.
me. But the fact remains that this was installed at some cost.
Course.
Now, if you remove it, it
Yes.
has to be put to some use.
Possibly, if it can be kept in this state somewhere, anyway, my lord.
That's for the registry
Anyway.
to think. So
But I was referring to that Mukesh Kumar judgment, 2023 SCC page 1. Has the Lordships got it?
para 18.
No, para 12 and 18.
Yeah.
My lord, for two proposition, I am placing the judgment. My lord, a reserved category candidate or a person, he does not have any vested right to claim as a right that there should be reservation in promotion or consequential seniority or any provision by law. Please come to para 12. Article 16(4) and 4A do not confer fundamental right to claim reservation in promotion. By relying upon earlier judgment of this court, it was held in Ajit Singh 2 that Article 14(4), 16(4) and 4A are in the nature of enabling provision, vesting a discretion on the government to consider, kindly mark the word, vesting a discretion on the state government to consider providing reservation if the circumstances so warrant. It is settled law that state government cannot be directed to provide reservation for appointment in public post. Similarly, state is not bound to make reservation for scheduled caste and scheduled tribe in matters of promotion. However, if they wish to exercise their discretion and make such a provision, state has, anyway, my lord, in the event they decide that they will have a provision, then what should be done, that is there. So we are regarding consequential seniority. Our stand is, my lord, state has expressly decided not to provide for it. Now please come to para 18 at page 12. My lord, may kindly come to placitum Z.
Yes.
Para 18, placitum Z.
Yes.
Even if last three sentence at page 12, even if the underrepresentation of scheduled caste and scheduled tribe in public service is brought to the notice of this court, no mandamus can be issued by this court to the state government to provide for reservation in the light of the law laid down by this court in C.A. Rajendran and Suresh Chand Gautam. Therefore, the direction given by the High Court that the state government should first collect data regarding adequacy or inadequacy of representation of scheduled caste and scheduled tribe in the government service, on the basis of which state government should take a decision whether or not to provide reservation in promotion, is contrary to the law laid down by this court and is accordingly set aside. So in this case, my lord, there was a direction by the High Court. The Supreme Court says, my lord, sorry, you can't do it. It is now, my lord, coming to the facts of the present case. What emerges is, in 1996, the state government's policy was accelerated seniority. Sorry, yes, catch-up principle, I'm sorry. Now, in 2002, based on the Constitution amendment, proceeding on the presumption or the premise that it is automatic, therefore, reservation in promotion, it was there, of course. Also, my lord, to that was added the consequential seniority. So that continued over a period of time, my lord. Nagras came, Act was amended in 2012, where the concept of replacement theory brought in. So, my lord, the entire thinking of the government of Assam with regard to reservation and consequential seniority changed. They came up with the, my lord, OM dated 29/12/14, where it is clearly said rosters are meant for identifying the points where reserve category would fit in. It is not for the purpose of, determining seniority. Well, since a single judge of this honorable court has held a contrary view, therefore, I will not invite your lordships to adjudicate on that aspect of the matter. Let us proceed for the moment that for 29/12/14 also does not alter the position. But certainly, my lord, clause 4 of OM dated 3/8/16 expressly provides that if a reserve category candidate has earned a promotion by virtue of roster, with that seniority, he cannot compete for a general post. Therefore, the position which emerges is, can 12/3/2002 and 3/8/16 coexist? Certainly, the answer is no. That's why, my lord, I refer to their judgment. Supreme Court says, my lord, ordinarily, there should not be any presumption in favor of a repeal, because normally repeal is to be done expressly. But in a given situation, when
Your,
the,
your argument before the single judge was it is by implication,
yes,
which the single judge
did
declined.
not accept. And my lord,
But-
because
but
of this,
upheld the powers of the government
to provide or not to
or
provide. Now state government has not provided
by expressly repeating.
expressly. Now my lord will see 3816, the same position is reiterated in my lord 18123. Therefore, the contention of the petitioners, my lord, that both the right, that is right, reservation in promotion coupled with consequential seniority is an automatic right of the reserved category is perhaps not correct. Now, my lord, division bench, I put forward two contention that in view of 291214 and 3816, it can be said that the state of Assam has done away. In fact, state of Assam has filed affidavit, my lord, whereby the state of Assam has taken a stand. We have done away with, consequential seniority. But that was not accepted by single judge. But division bench, my lord, has clarified. Now, division bench did not appeal our contention from the perspective of 291214, but from the perspective of 3816, my lord, 12/3/2002 has been clearly explained. Now, if your lordship would kindly take the judgment for a while, that writ appeal judgment. Yes. One second. My lord will kindly come to page number 19 for a moment. Internal.
Just 1 minute.
Sorry.
Yes.
Lordship should kindly come to page 20 internal, para 19.
Yes.
N. Chaudhary led a Sine Council for the appellant IV Gohai Dasgupta and other appellants in writ appeal has raised the contention that by office memorandum dated 29/12/14, the consequential seniority meted to reserved category candidate by earlier office memorandum dated 12/3/2002 has been superseded, meaning thereby the provision of consequential seniority pursuant to the enabling provision had been withdrawn. So this was our contention, my lord. Then lordship need not, please come to then paragraph 29. Please come to para 20, page 26.
Yes.
Last four sentence, my lord. From such point of view, has your lordship got it?
Yes.
From such point of view, we are in agreement with Ken Chaudhary, Lanet Sine Council, that office memorandum dated 29/12/14 would have also withdrawn the benefit of consequential seniority meted to reserved category candidate by earlier office memorandum dated 12/3/2002. But at the same time, although enabling provision enables state authorities to withdraw such benefit, but what would further have to be examined as to whether office memorandum dated 29/12/14 in fact withdraws the benefit of consequential seniority meted out by office memorandum dated 12/3/2002. Then my lord will kindly come to para 37. Page 30. So that was from that perspective, the learned division bench, my lord, looked at the matter, and this is how they concluded. Accordingly, it would have to be concluded that a conjoint reading of clause 1.11 and 14 of OM dated would mean that consequential seniority that was otherwise meted by office memorandum had not been withdrawn. So therefore, qua 29/12/14, my lord, my contention was rejected. Now please come to paragraph 44 at page 34. In between, the learned single judge discusses about the, my lord, other aspects regarding that, my lord, collection of quantifiable data, which was
Equality.
argued by my friend Mr. M.K. Chaudhary.
Equality.
Para 44.
Yes.
Now, as regards the interpretation of clause 4 of the office memorandum dated 3/8/16, we again quote the said provision, which is as below. If an occasion arises during promotion process in which the stipulated percentage in respect of reserve category is met, but in the gradation list, seniority list, there are candidates of reserve category who on merit is entitled to promotion, her case shall be considered for promotion on merit if such candidate has not gained a seniority by way of accelerated promotion early. A reading of clause 4 makes it discernible that if an occasion arises during promotion process in which stipulated percentage in respect of reserve category is met, but in the gradation list, there are candidates of reserve category who on merit are also entitled to promotion, his or her case are to be considered for promotion on merit, only if such candidate has not given seniority by way of accelerated promotion. It would mean, now qualifies, the land division bench qualifies its view. It would mean that if a reserve category candidate is seeking for a promotion against any post in the promoted cadre, which is earmarked for a reserve category candidate, he would be entitled to the benefit of consequential seniority as provided in the office memorandum dated 12/3/2002. I'll pause here for a moment, my lord. Now, what division bench, in my humble understanding, has held is that that person who has earned a promotion by application of roster and consequential seniority, that seniority can be used for the purpose of getting the benefit of 12/3/2002 only to a post which is reserve category post, not to general category post. But on the other hand, if the post earmarked for reserve category candidates are already exhausted by being occupied by reserve category candidates, but in the gradation list there remains some further reserve category candidates, they can compete for promotion again unreserved post. But in such an event, they would not be entitled to benefit under consequential seniority. And on the other hand, if on the basis of the seniority otherwise, without taking note of consequential seniority, they are within the zone of consideration, such candidate can be considered for promotion. So the second limb of the conclusion in this para 45 was a reserve category candidate who is otherwise within the zone of consideration without considering his consequential seniority or accelerated promotion, then perhaps he can be considered. Now, my lord, where is the scope to say that division bench has upheld the learned single judge's order? Division bench has clearly taken a contrary view. So that being the position, my lord, now where is the scope to argue that Bhagavan Patar's in the judgment of the learned single judge in Bhagavan Patar has been reaffirmed by, the division bench? The division bench has held to the contrary. In other words, 12/3/2002 has been explained. In what situation 12/3/2002 can be made applicable? It can't be made applicable per se. It can be made applicable with a rider. The rider is,
Can you come to the lines?
yes, my lord.
It would mean that para 45.
One second. Yes. It would mean that if a reserve category candidate is seeking for a promotion against any post in the promoted cadre, which is earmarked for a reserve category candidate, he would be entitled to the benefits of consequential seniority as provided in the office memorandum. I'll just pause here for a moment, my lord. My humble understanding is what division bench has held is by virtue of the seniority thus acquired by reservation in promotion or application of roster, that seniority can be used for securing a promotion to a post which is otherwise reserved for reserve. That means if the category to whom the candidate belongs, there is a post in the promoted cadre earmarked for reserve category, to that post he will have a rightful claim.
There is no difficulty in that.
Yes.
Because that is what is laid down by Sabharwal.
Yes.
You have these posts identified.
Ah.
So X goes to X1, Y goes to Y1,
Correct.
goes to Z1. What is the meaning to say that he will have the benefit of consequential seniority?
Yes, consequential seniority is provided by 12-3-2002. So that benefit you can avail only for a reserved category, qua a reserved category, not against the post reserved, unreserved post. Because,
No. There are, subject to correction,
yes,
there are two issues here.
Yes.
There are two situations here. One is filling up of the post,
Hmm.
reserved, unreserved. This is one compartment. The other is, both these compartments will now have to be placed under a common gradation list.
yes.
This is where the question of consequential
No.
seniority or catch-up rule comes
No,
in.
my lord, I'll make a submission on that.
Hmm.
Now, perhaps one of the argument of my learned friend is also that principle of continuous officiation should be applied so that seniority can be fixed as per the rules. My lord, this is neither here nor there. They never earned a promotion by a regularly constituted DBC by competing with every person who is in the zone of consideration. They were never considered. They were just picked up because there is a slot. So that argument will not come.
From day one,
Yes,
we are trying to understand the
Yes.
true import of para 45.
my lord,
So-
my humble way of understanding para 45 is it has got two parts.
Because if there is no doubt
Hmm.
that a reserve category will go to a reserve, unreserved will go to unreserved generally.
Yes,
Once you fill that up
Ah.
and you give the reserve category the benefit of consequential seniority in terms of 2002, then 2002 did not bring in catch-up rule.
no,
You'll have to be
no, 2003 was never meant to bring catch-up principle.
Hmm.
2002 was meant to confer consequential
Seniority.
seniority. Let us not confuse about that. Now, our case is the position had changed, at least now because of both the judgment with effect from 3816.
so therefore
With effect from
those-
3816,
those
there is a
can-
change in the law.
So therefore, those candidates who had come in through the channel,
Ah.
their consequential seniority will be available to them.
No,
Reserve category.
no. They may have earned the promotion, but when it comes to going to the next higher grade, then my lord 3816 will come. There they cannot avail the benefit.
Anyway, so
No, my lord, no. Naturally, it's
this is what we are asking you, because you see,
Yes, yes.
one is the compartments,
Hmm.
one is the placement. There is no quarrel on that. It's a replacement, as you have rightly put. The other is what happens when he gets the benefit
Hmm.
through that replacement to the next higher post.
My lord, to make the position,
In terms
No, my lord,
as interpreted
no,
by the
to
division
make the
bench.
position clear, would your lordships kindly come to 3816 for a once?
Yes.
3816. In the writ petition, it is at page 63.
Yes.
Perhaps this will clear your lordship's query. Affidavit copy to court. Affidavit con is a state file করেছিল। Huh? Huh. It will. My lord, during the pendency of the proceeding before the learned single judge, this honorable court posed a question asking the government to put their stand in an affidavit whether they are pursuing the policy or not. There they came up with this. I've just made a compilation, that affidavit. Huh? Oh, ठीक है, ठीक है. Oh. এইটোৱে আগৰ এফিডেভিটখন বুজক।
Yes.
1 second, my lord. এফিডেভিটখন ক'ত? Page 1 to 15. নহয়। No, এইখন কি দিলা?
This is by
I'm sorry, my lord. This is not the right document. I'm sorry. এখন নহয় এই যে গভৰ্ণমেণ্টৰ এফিডেভিট দুখন আছিল আজিকালি হ'ব গভৰ্ণমেণ্টে দি আছে 1 second sorry that's not the one বেলেগ ফাইলত আছে নেকি চোৱাচোন ইয়াত। One second. Open ক'ত পালা? নহয় এখন তাহাঁতৰ আছে মোৰ নহয় এখন তাহাঁতে দিয়া
Anyway, some affidavit was filed.
In that
Then supply
affidavit,
claim.
my lord, a
Yeah.
clear stand was taken where government said the same thing. That this seniority can be used only for earning a promotion against the reserve category. The reason is very simple, my lord. Within their stream, general will not come in to poke their nose. And they will not come to poke their nose in a general stream. If you have earned an roster promotion and consequential seniority. Now, in this case, admittedly, by virtue of 12/3/2002, they have all along been getting the benefit. Now, for the first time, in 3/8/16, state government came up with a clear policy decision saying a reserve category candidate cannot count their seniority if a particular post is meant for general category. Meaning thereby, 12/3/2002 has been impliedly repealed. I don't know why the learned single judge did not record that finding, my lord. I find it very difficult. But then there is a judgment, I cannot say anything. It's very clear and simple thing, my lord. It's to repeal by necessary implication. Because can we envisage a situation where 12/3/2002 will also survive? 3/8/16 will also survive. That's what precisely Supreme Court says, my lord. So that being the position, therefore to say that, my lord, consequence and seniority will continue, in my humble understanding, cannot be, my lord, receive judicial imprimatur. Now, again coming to para 45, my humble submission is, my lord, if we read the sentence from last 5 lines, but on the other hand, if the posts earmarked for reserve category candidate are already exhausted by being occupied by reserve category candidate, but in the gradation list, there remains some further reserve category candidate, they can compete for promotion against unreserved posts, but in such an event, they would not be entitled to the benefit under consequential seniority. On the other hand, if on the basis of the seniority otherwise, without taking note of the consequential seniority, they are within the zone of consideration, such candidates can be considered for promotion. In other words, if in the promoted category, maybe the reserve category candidate by virtue of roster promotion is higher on merit, he will be come into the zone of consideration provided his seniority can be counted minus that accelerated promotion. The moment accelerated promotion comes, then that seniority cannot be taken note of. In other words, he will not be construed to be in the zone of consideration. So in my humble understanding, my lord, the judgment is clear. It is only against a reserve category post in the promoted category. The consequential seniority which has been conferred by 12/3/2002 can be invoked, not for any other purpose. So that is my humble understanding. So therefore, my lord, to say that the petitioners has been able to make out a case is absolutely wrong, my lord. Now the law is very clear. It is an enabling provision. It is for the particular state to take a call whether to provide either reservation in promotion and consequential seniority, or no reservation in promotion, in which event there will be no, occasion to give consequential seniority. Now, in Paneer Silvam's case, my lord, the similar argument was upheld by the High Court, which was expressly rejected. So that is the position. Therefore, my lord, the 18/1/2003 is nothing but an extension of, my lord, clause 4 of 3/8/16. And that being the position, the writ petition is, my lord, absolutely, misconceived. And as pointed out by the learned Additional Advocate General, my lord, it's a fact that when I approached the writ petition, the writ appeal was pending. Their entire case is premised on the basis that Bhagavan Patar's case has been upheld by the learned single judge. Therefore, they have a consequential right. That position seems to be not correct. And while my learned friend opening the argument, for a moment also he never referred to para 45 to say that a contrary view has been taken. So end of the day, my lord, the position is clear.
Yes.
If the policy of the government has decided, no, end of the matter. There cannot be any mandamus as held by the Supreme Court in my lord. My lord, the other point that by necessary implication it is no longer there, that is not required to be gone into for the simple reason the para 45 finding is good enough to protect our interest. Otherwise, I feel, my lord, I respectfully submit that is a point which could have been dealt with in a better way anyway, my lord. That's a judicial discretion. And we had gone on appeal. And once, my lord, the scope of 12-3-2002 has been explained by the division bench, my lord, our concern is addressed. So in effect, para 45 answers our concern. It explains in what situation 12-3-2000 will operate. It will operate in a situation where there is in the promoted cadre, there is a reserve category. So that we are not disputing. If there is a promotion in the reserve category, a promotional avenue for the reserve candidate, he can still use his seniority as is conferred by 12-3-2000. That's my humble submission.
Yes.
Well, then I'll just take your lordship to the brief points.
I think nothing much to reply because
Yes.
it's
But
put
I'll
on the
reply to-
interpretation.
Yes. The
Yes.
two interpretations, similar interpretation has been given by the.
Just
editions
1
of
minute.
Tasman.
Mr. Chaudhary,
My lord,
you have already submitted your written
yes, I've given
argument.
my written.
Okay. That will encompass all
Yes,
your
yes.
oral
My lord, I have given the right from the very beginning, how in my understanding, how it operates. What is the position?
Yeah,
No, no, your submissions.
Everything is there.
All right. Yes.
My lord, I have two matters.
Excellent, Baba. My lord, if your lordship would kindly permit me, I've got the affidavit which was filed by the state. Can I just place that paragraph, my lord? One second.
Is it available in the
Yeah,
PDF?
no, yes. No, it will be. One paragraph, my lord.
It's not available in the bunch of papers. Otherwise,
This judge, no, 2999 has been withdrawn because it has become, lordship can call for that file, my lord. 2999 of 2020. Now, there was an order passed by this honorable court on 14/9/2020, whereby the learned single judge directed the state to file an affidavit stating whether the policy of consequential seniority is there or not. Now, the state's reply at para 3.
yes.
Now, please come to my lord, page 144. In page 144, my lord. In point number 2 of OM dated 3/8/16 by WPTBC department, it is mentioned that each establishment, while taking up the process of promotion in a particular cadre of service, shall examine the representation of SC, STP, and STH candidate in the cadre in comparison with the prescribed percent of the reservation and calculate shortfall, if any, in the cadre with reference to that particular year. Shortfall of reservation of a particular reserve category in cadre means difference between the total number of posts for that category in the cadre and number of persons of that category holding the post in the cadre. While calculating the shortfall, all candidates belonging to the same category shall be taken into account, irrespective of the mode of their entry into service cadre, that is, whether on account of seniority come merit, merit come seniority as the case may be, or through any other process admissible in law or by way of reservation. If in a particular cadre state STs are not adequately represented and shortfall is found to exist in the cadre, they may be considered as backward insofar as that particular cadre is concerned. Such shortfalls shall be filled up by concerned category of incumbents within the zone of consideration, either on account of seniority, come merit, merit come seniority, or by a providing reservation, as the case may be, till the prescribed percentage in respect of such category is achieved. Accordingly, representation of SC, STP, STH candidate in the cadre in comparison with prescribed percentage of reservation is calculated to determine the shortfall, if any. Further, point number 4 that I have already read. Now this come to these two subpara. Thus it is seen that seniority in promotion for reserved category is applicable for promotion against shortfall reserved category post only. These officers of reserved category who have availed an accelerated promotion earlier are not eligible by virtue of their thus acquired seniority in the subsequent promotional process against the unreserved post. So this was the clear stand of the statement. So, my lord, therefore, the state's policy is absolutely clear. They said if there is any shortfall, to fill up that shortfall, that seniority can be used. That means 12/3/2002 can be invoked only for the purpose of addressing the concern, addressing the shortfall vacancy, not to general category. So I wanted to rely upon this. And this was pursuant to a specific order of this honorable court. State was directed to make their position clear.
My lord,
Yes.
I have item 6 and 17 now, and I want to advance my argument. I am
You are for
Let
the,
him-
you are for the petitioner.
for the petitioner.
Let him complete.
Let him complete, let him give the reply.
Here, I'll just want to point out, 6 and 17 has nothing to do with this issue because my learned friend has obtained a stay order about a year back, placing an erroneous judgment of this court. Like, I had filed my vacating application. and
You are a party there.
I am a respondent who has been promoted a year back on top of the list, but because of the stay order, in fact, on the earlier occasion, I made a mention before a single judge. And this, my learned friend took it and tagged it with this case. Well, I want that this matter should be taken up at least with, in the last part of this week. Because for no fault of mine, this injunction has nothing to do with consequential seniority. I'll show from my submission. So Lordship will take up this matter on Thursday or Friday.
First, you complete
Yes,
your
yes,
reply.
I'll complete.
Then
Since he had made a mention, it was my.
we will see if it can be taken up today. We'll take it.
Yes,
Otherwise,
I'm ready.
I am ready, man.
yes, yes.
Well, in fact, I won't take much time. The two arguments were advanced by the state as well as by the private respondents. Well, the two arguments which was advanced, which forms the anchor sheet of their argument, is that the Assam government has got a power given to them under Bhagawan Patter, which I'll refer to, where a license has been given to them to give or not to give. And taking that power, they have now brought in this OM of 2023. Lordship, I'll take your lordship to the Bhagawan Patter judgment because that is the genesis of all the problem. Well, lordship will come to page 106. In fact, the operative part starts from 103. If I may read, lordship, I'll just clear the points. D, whether clause 4 is violative of section 5 of the 78 Act and therefore liable to be struck down. Clause 4 of the offending office memorandum provides that in a given situation when the percentage earmark is achieved, but some reserved category who on their own merit are entitled to promotion, his or her promotion shall be considered on merit, subject to the further condition that the said person has not gained any seniority by way of accelerated promotion. Thus, from a reading of clause 4, it is clear that a consequential seniority is withdrawn for those persons belonging to SC/ST who are eligible for promotion on merit, but has got accelerated promotion. The said clause nowhere declares that the policy of consequential seniority shall henceforth not be applicable to all the promotions made under section 5 of the 78 Act. That being the position, Well, this is the ratio. This court unhesitantly holds that the policy of providing reservation in promotion with consequential seniority being holding the field as per OM of 12/3/2002, the state is not within its competence and jurisdiction to deprive such service benefit to a meritorious reserve category, and that too without expressly bringing such policy by superseding the benefit granted under OM of 12/3/2002. So the learned single judge used the word meritorious reserve candidate. Why it referred? Because our entire argument was that by bringing clause 4, you are putting fetters on us to compete on merit as a member of the unreserved, which you cannot do it. And the learned single judge was convinced that this provision of meritorious reserve candidate, why is the learned single judge using the word meritorious? Because the clearly OM says that you will be given provided you didn't get it earlier by consequential seniority. My lord, section 5 of the act. Here I will just differentiate. There was an erroneous argument by my learned friend, Mr. Majumdar, when he said, I argued on 5A of the post base. I never argued on 5A. I know where I stand. Section 5A clearly talks about roster promotion. Roster promotion envisages accelerated promotion and consequential seniority, totally settled by the 16/4 amendment of the 77 amendment. And the contention that it is not automatic is wrong for the simple reason that it is automatic now in view of the provisions of the rules. That is the OM of 2002. It holds the field because the lordship will see the consequential seniority is a benefit. The judge uses the term, the learned single judge, that superseding the benefit given under 12/3/2002. Malad, the benefit of consequential seniority could not have been given to the reserve in Assam if this OM was not there. So he talks about that if you have to supersede, the power flows from 7/5. And if you have to abrogate.
Mr.
5.
Das.
Yes.
The basis of the single bench and the division bench,
Yes.
judgment, whichever way you interpret, is on the ground that there was a provision of consequential seniority
Yes.
in terms of 2002.
Till today, yes.
So 16, according to Mr. Chaudhary's client, had impliedly overruled 2002.
That was rejected
That was rejected.
by both the benches.
Now, at this stage,
Yes.
you are challenging this notification, which has expressly overruled 2002 and 16.
Malan,
This notification and the challenge has expressly
OM of 23, yes.
overruled.
Yes.
But the finding of the single bench,
Yes.
as also the division bench,
Hmm.
that the state is within its power to give or not to give.
No, my lord, why is there?
Has not been assailed.
Yes, my lord, para 9. Why is the, my learned friend, the government council repeatedly not
No, Mr. Das,
reading
what
the
we are
code?
trying to tell you is 2002 and 2016, what it gave, what it did not give is there in the single bench and division bench judgment.
Yes.
Now, in view of this later notification, the question is, the later notification,
Of 2023.
you have to tell us the grounds why you
No,
are
the
putting
first-
to challenge.
Yes, the first ground is that the rule of 2023
Hmm.
basically brought in the dead principle of catch-up. Because your lordship,
Okay.
an argument was advanced by my learned counsel that by bringing in, we have repealed the consequential seniority. If so, why is in the OM of 2023, the consequential seniority is there for the members of C, D, E class? Is it that this is a machine that as and when we want, will operate? Malad, the 2023 OM has both catch-up as well as it is totally bordering on absurdity. Because for the simple reason, lordship will find the learned single judge, when he used the term at paragraph 105, page 105, Roman 9.
No, but both the courts had expressly held that it is within the powers of the government.
But,
to give or not to
Malad,
give.
no, provided it is Nagras and journal compliant, why are they not reading it?
But you are not in appeal against those judgments,
Malad,
against the
which-
division bench
appeal-
judgment.
Which judgment?
Division bench judgment. Division bench judgment.
Paragraph 45, now I'll explain. to show
We
how
are
it
only
doesn't go
trying to,
against.
Mr. Das,
it
we
goes in their
we have not
favor.
made up our minds.
No,
We are only
but
trying
it's
to
my
understand that what is the ground on
Your
which you are
lordship was-
challenging.
Yes, your lordship was
Your
repeatedly
first ground
harping
is
on
that,
paragraph
your
45.
first ground is that it is a catch-up principle which is non-existent today.
Malad,
And you are trying to bring it.
My challenge is that
Yes.
the fact that they brought in the catch-up principle and they denied us the benefit of consequential seniority could not have been a power vested in the personnel department when the 78 Act specifically
That
calls
is
for it.
exactly what was
I don't
held.
you withdraw the act. Malad, if they
No,
withdraw
but that
the-
is exactly held in the earlier round of litigation. That is exactly held in the earlier round of litigation.
Yes, and
Assuming the division bench judgment is not there, assuming IV, what is that?
I will
Dasgupta.
go on.
IV Gohai is not there. Even if we go by Bhagavan Patter, that's a coordinate bench view, ordinarily binding, unless I take a different
They
view.
comply with it because they want to get over the Bhagavan Patter. So they brought in the OMO 2023.
You are not answering the question.
Yes, sir.
The issue decided by the single bench is that 2002 had given the benefit to the reserve categories, consequential seniority. 2016 was brought in to say that we have done away with. Single bench held that no, 2016 did not expressly overrule. So until the government brings a new notification, and in that sense, court held that it is within the realm of the government to give or not to give.
Lordship,
But
I'll have to
once-
explain paragraph
once-
9. It is not so. The government, Lordship will find article, if your Lordship. takes
Para
up
9,
article
para 9 of,
Para 9, Roman 9 of 100 page 105.
yes,
For my third, this is the third round of submission I'm making.
yes. Please.
Article 16.4a and 16.4b being enabling provision, the state is at liberty to implement its policy of giving reservation in promotion
Mm.
with consequential seniority, at liberty to provide for reservation in promotion without consequential seniority, or at liberty not to provide any reservation in promotion. However, while implementing, adopting, changing under these three scenarios, such policy due process of law need to be followed, including the dicta of Nagraj and Journal. I could satisfy Lordship that if the dicta of Nagraj is to be compliant, it has the Assam government by bringing in the 2002 has complied with the dicta because Nagraj has upheld 16.4a giving accelerated promotion and consequential seniority. That is
Has held subject to making it enabling provision.
no, my lord. Subject, my lord.
They're
Subject to
subject
the.
to-
my lord,
subject-
where is the question of enabling when the 2002 is in operation? Can they disable it? It's an enforceable right. And journal saying cadre wise, my lord, the lordship knows. we
So,
have-
so your challenge is
Yes.
that 2002,
Yes,
once having been brought in, could not have been withdrawn.
and my merit
Actually, is
cannot
that-
be taken away because the
Sorry?
judge specifically said meritorious reserve because the entire cases are all persons who were getting on
We
merit.
have to formulate your argument
Yes,
so
yes.
that we can answer it.
Yes, your lordship.
So what is the first argument is that you have brought
It is
in the
ju-
catch-up principle, which is dead, which was never in existence, which has been given up,
It is not there. The Assam government's personnel department has withdrawn it.
withdrawn it, whatever.
So who has
Now-
given
now
them
you are-
authority to bring in now?
Right. Then the second,
Second, the power flows from section 5 of the act,
Mm.
which is discernible. And the fact that since power flows, the roster promotion envisages a accelerated promotion and consequential seniority, you could not have abrogated that power because in that power, you have also put a factor that you will not be considered as a member of the unreserved. That is the crux. And from paragraph 45, I'll show. You will be considered as a member of the reserve. Well, this is unheard of. Nowhere in India, this sort of a rule is there. Only the personnel department in the Assam will have to be given credit. Well, Lordship will find that section 5, Lordship will, I'll take your Lordship to section 5, clause B.
yes,
A separate post-based roster for recruitment and promotion for each cadre will be maintained by every establishment for reservation of the SC and ST. Why is the word being used? Each cadre because my entire case is that the cadre promotions, you are depriving me retrospectively, because for a long time I have earned that cadre promotion and seniority. Now with a stroke of a pen, you take away that right. So power rightly, the single judge has held section 5 clause B, a separate post-based roster for recruitment and promotion for each cadre shall be maintained by every establishment for reservation of SC and ST. Lordship will find that the word is for each cadre, means in each cadre when I go up, my seniority has to be given to me because the rules provide for it. The gradation list has to be made in terms of cadre wise. The rules never envisage an alien concept of date of entry into service. When I entered my service about 30 years back, and the government of Assam, since they cannot attack the 78 Act, section 5, what they do, in order to the back door, they bring in the catch-up principle by the clause 4 of the 2016 OM and clause 4 of the 2023 OM, by expressly stating that we are now bringing the catch-up principle. Grade A officer will be deprived of the benefit of consequential seniority, and grade C, D, lower officers will be given the benefit of consequential seniority. But what is the Assam government trying to do? And ultimately, Lordship, on the last occasion, I conclusively showed that journals 2 is an issue which has been decided by the Supreme Court. And on this point, that it has to be cadre-wise. It cannot be the date. It cannot be group-wise. And Assam government has done the mistake of making it into groups. They have split up the cadres into groups, A, B, C, D. And that is why the learned single judge rightly says that the implementation, adopting, changing of such policy has to be NAGRAS and journal compliant. And I could successfully show that it is not journal compliant or NAGRAS compliant.
Yes.
The second argument of my learned friend, the government, my learned friend, Mr. Mojumdar, he made a submission which I never made. I will not make a submission where I'll be caught at the end. He says that 5A, where does Mr. Das get consequential seniority? I don't have to bring in 5A. 5A is a post-based reservation, which has been brought in. In fact, the concept, Lordship, one thing I'd like to again repeat. Lordship will turn to the OM of 2014 at page 58.
Just a minute.
Well, your Lordship will take up the OM of December 2014, pursuant to the R.K. Sabharwal's case at page 60. Can I read?
Yes, yes. No, this we have already gone
Yes,
into.
well, I want to show if
No.
the rules are specific, that at
We have
all
already
levels
gone
you will get on merit and you will go as a member of the
We
unreserved.
are now asking you
Yes.
for your reply. If
Yes.
you have any. You have already submitted, we have recorded all
Yes,
that.
by reply to the first query, as regards 45, I'll make my submission.
Hmm.
Can I make
45,
45? Para 40.
para 40. Okay.
Well, as regards this, I think I have been clear. I have also satisfied your Lordship that on the earlier two occasions that the rules and which says a cadre-wise promotion, which the 2023 negated.
And which has been upheld in journal.
Journal is
It
holding
has
the
to be
field.
cadre wise.
Yes. If not, you don't come to a situation, no promotions can be
There
given.
cannot be a wholesome picture of.
No, wholesome
uh,
picture will
reserve
not give
or
a
unreserved.
correct
It
picture.
must be
Yes.
identified cadre wise.
Yes.
And which is on the basis of the exercise required to be done by the state.
Yes. And your Lordship has rightly said that as I come up for last 25 years, I get my seniority. Only in the year 2023 does this thing happen, and so many cases are there, that all seniority I lose, I come down, my merit is not considered. But as regards 45, an argument has been advanced by both the parties that paragraph 45 goes in their favor Well, and I'll show that paragraph 45 basically leads to two situations. Well, a lordship will find that paragraph 45 can be split up into three parts. The first part, the learned single judge says that for the earmark post of the reserve, you will be entitled to everything. Accelerated promotion and consequential seniority. Towards the middle, he says, if I may read, but on the other hand, if the post earmarked for the reserve category candidates are already exhausted by being occupied by the reserve candidates, but in the gradation list, there remain some further reserve candidates, they can compete for promotion against the unreserved post. But in such event, they would not be entitled to the benefits under consequential seniority. My lord, if we are to accept this, then your lordship, the Assam government will now has taken this argument, but very good. Their argument is that this paragraph goes in their favor. If it goes against this favor, then the Assam government will also have to run the risk of accepting that this paragraph is in violation of clause 4, paragraph 4 of R.K. Sabharwal. Because lordship, the distinction has been now made in paragraph 45 between a reserve and an unreserved. And Assam government wants to do the mischief of giving us the benefit only for the reserve, and for the unreserved, they want to form a quota for the general on merit. And this has been deprecated in a recent case of the Supreme Court in Saurav Yadav, where, well, it's 2021 4 SEC 542, where the Supreme Court says if we allow that for the reserve, unreserved, the reserve won't be able to compete, we are bringing in communal reservation, which is deprecated by Indra Swani. 2021 4 SEC.
Paragraphs?
Well, paragraph 66, well, here also it was vertical and horizontal reservation. They wanted to bring into groups. I would conclude by saying that reservation, both vertical and horizontal, are methods of representing and showing representation in public service. Lordship has found paragraph 66. Last
Yes.
paragraph, last
Yes.
but second.
Yes.
I would conclude by saying that reservation, both vertical and horizontal, are methods of ensuring reservation in public service. They are not to be seen as rigid slots, where a candidate's merit which otherwise entitles her to be shown in the open category is foreclosed. We are foreclosed. As the consequence would be if the state argument is accepted, doing so would result in a communal reservation, which the Assam government wants to do now, where each social category is confined within the extent of the reservation, thus negating merit. The open category is open to all, and the only condition of a candidate to be shown in its merit, regardless of whether the reservation benefit or other type is available to him or her. So I want to say that if the Assam government now agrees, as from the submission, they are saying that this supports us, then definitely they will have to run the risk.
What is the meaning of this?
Well, this meaning comes from Sabharwal's paragraph 4, which I read on the second occasion.
Yeah.
Paragraph 4 of R.K. Sabharwal.
Yes.
Well, we have given in my compilation also. And this was the argument I made in the learned single judge also. So the learned single judge used the word, you cannot deprive the meritorious reserve. The Assam government wants to form a quota for the general on merit. Nowhere in India it is. Here it is there, it will have to go. Well, can I read 4? Because if you start categorizing, you already have admitted that you will come only in the reserve. Well, page 22 of our compilation.
Yes.
When a percentage of reservation is fixed in respect of a particular cadre and the roster indicates the reserve point, it has to be taken that the posts shown at the reserve points are to be filled up amongst the members of the reserve category. And the candidates belonging to the general category are not entitled to be considered for reserve post. Can I read?
Yes.
On the other hand, the reserve category candidates can compete for non-reserve posts, which in Assam we cannot do it. And in the event of the appointment to the post, their numbers cannot be added and taken into consideration for working out the percentage of reservation. The personnel department, in my submission, has done this mischief in the Praveer Kakoti's case. What they do, they don't make cadre, they make it into one small, big group of 900 officers, and they start picking up vacancy wise. They don't consider that when we go on merit, we go as a member of the unreserved. They say that the prescribed percentage is finished, that post now will go to the general. Well, what more is required? Well, mischief you do if you have the mechanism to do it. Your mischief is not supported by the constitution or by the rules or by the nothing. So, Lordship, I just Article 16(4) of the Constitution permits the state government to make any provision for reservation of post or appointments in favor of any backward class or citizen, which in the opinion of the state is not adequately represented in service. It is therefore incumbent on the state government to reach a conclusion that the backward classes for which reservation is made is not adequately represented to the state service. While doing so, the state government may take the total population of a particular backward class and its representation in the state service. When the state government, after doing the necessary exercise, makes reservation and provides the extent or percentage of posts to be reserved for the said backward class, that percentage has to be followed strictly. The prescribed percentage cannot be varied or changed simply because some of the reserve members of the backward class has already been appointed, promoted against the general seats. That's the thing which the Assam government is doing. As mentioned above, the roster point which is reserved for the backward class has to be filled up by way of appointment, promotion of the members of the said class. No general category candidates can be appointed against a slot in the roster which is reserved for the backward. In the fact that considerable number of backward classes has been appointed or promoted against general category may be the relevant factor for the state government to review the question of continuing reservation for the said class. In Assam, it is continuing. But so long as the instructions and the rules providing that percentage of reservation for the backwards are operated, the same has to be followed. Despite any number of promotions and appointees belonging to the backward class against general category posts, the given percentage has to be provided in addition. We therefore see no force in the first contention raised by the Learned Council and reject the same, because their contention was that unreserved, you will not get it. So that was rejected. So that is the law, my lord. So if this argument of the respondent state, well, I'm more concerned with this because the beneficiaries of the members of the general, they will argue their case. They've argued their case. But the state taking a view that we feel that paragraph 45 is in our favor, the middle part, the second limb. If they do it, well and good. Well, it will be good for us. Why? Then they are accepting that the said clause is basically violative of R.K. Sabharwal. And when it is held that if a reserve candidate operates on merit, he has to be treated as a member of the unreserved. So their argument to say that in the unreserved part, you have no say. You will not be given anything. So my contention, my submission is that the entire submission that paragraph 45 goes in their favor is without any basis because they could not differentiate.
So if it doesn't go in your favor, in their favor, it must have gone in your favor.
Well, it will go in my favor because it adds with a qualifying that if I'm otherwise eligible, I'll be, and what is this otherwise? It is under the rules. Because ultimately, when I compete on merit, well, it is not a competition by subterfuge. It is by competition. Our ACRs are taken up vis-a-vis the general. So, Lordship, if I come within the ambit of the last part, if on the other hand, if on the basis of their seniority, otherwise, that is other rules, without taking note of the consequential seniority, they are within the zone, such candidate can be considered. And I have not been considered since 2016 because the fetter of 16 and now the fetter of 2003, clause 4 remains. Because as soon as I go, they say that you have a birthmark, you cannot go. And that is the violation, that's the constitutional one. And as regard the judgment, my lord, I will not repeat. Pena Silvam's case was rightly said by my learned friends that it will not be automatic. My submission is not automatic. I don't make automatic submission. It is absent, in the absence of rules, they gave it. You can't do it. And as regards the second submission of my learned friend regarding Mukesh Kumar is that the Uttarakhand government took a decision not to give reservation. And they went on the High Court and direct the government that you have to collect quantifiable data. Supreme Court says no. It's an enabling provision. If the government wants to give it, they will give it. Why you ban numbers? That judgment has got no relevance with my case. It's an enforceable right. I have already quoted judgment from Chairman's Supreme Court judgment, Honorable Justice Chalamishra's judgment, para 31 of that bank's case, that when it's an enforceable right, if it is enabled, it's an enforceable right. We can go and seek remedies, and that is what I'm doing in this case. So this is my submission. In view of that, the OM of 2023 does not stand scrutiny of law. It has to be quashed, those clauses, not all. And cadre-wise promotions need to be effected.
You
in
want
terms
to
of the-
distinguish Mukesh Kumar by which judgment?
Mukesh Kumar's judgment is of 2000. That is page 70 of our compilation.
2016 one.
Yes. 355. Para 31. So single and division bench has held that the 2002, it's an enabling, it is still enabled, it is not withdrawn.
Okay.
Paragraph 24, Lordship.
All right.
Page, last part, if I may read that before I complete. There is no doubt power lies with the state
Yes.
to make a page 81, Lordship.
Yes.
Last part of paragraph 24. There is no doubt power lies with the state to make provision, but at the same time, courts cannot issue a mandamus to the state to necessarily make such a provision. It is for the state to act in a given situation and to make such an affirmative action or course. Whenever there exists such a provision for reservation in a matter of recruitment or promotion, it would bestow an enforceable right in favor of the members belonging to the SC/ST. And on the failure on the part of the authority to reserve post while making promotion selection, the beneficiaries of those provisions can approach the court to get their rights vindicated. What is to be highlighted is that the existence of a provision for reservation in the matter of selection and promotion is the sine qua non for seeking a mandamus, and it is only when such a provision is made by the state a right shall accrue. In our case, right accrues because the act is there, power flows from the act. Either you withdraw the act and leave us with no benefit.
My lord,
Obliged.
I'll have to give 5 minutes reply, my lord. I'm sorry for that. Now, my lord, my learned friend is talking about merit. A meritorious among the reserved category, they should not be denied. My lord, I can appreciate that argument if we are arguing a case of direct recruitment. In Sabharwal's case, Honorable Supreme Court had said, if a reserved category candidate by virtue of his merit makes within the, my lord, by competing with the general, if they come into the scene, then he is to be treated as a general, he is not to be treated as a reserved category. But how do we apply that principle in a promotional matter, my lord? In promotion, the first thing that has to be carved out is the zone of consideration. That is where is the catch. Well, my learned friend is referring to this Saurabh Yadav. Saurabh Yadav is a case of, my lord, a vertical and, my lord, horizontal reservation. How does it apply in this case? How does he, my learned friend is explaining para 45? I think it's intelligible to him. He's intelligible enough to understand that. But let us not make a mockery out of it, my lord, merely because we are arguing a case. My lord, that merit concept will come into play only when, my lord, it is a case of direct recruitment. But in a case of promotion, the first hurdle a reserved category candidate has to overcome is he has to be within the zone of consideration. First, he has to come in the zone, then his merit will be assessed. Now, we are concerned with the zone. Now, zone he will come, provided he has not earned his accelerated promotion. Otherwise, he will not come. If he doesn't come, where is the occasion to assess his merit? That is what Ajit Singh in para 9 said, my lord. That when they were promoted, they are not assessed with the reserve category candidate. Only by virtue of roster they were promoted because there is a slot for them. So, my lord, this argument is wholly misconceived. Now, my lord,
Yes.
my learned friend is also making an argument of that this 18.123 notification has discarded the Cather principle. My lord, there is a very subtle argument, my lord. I will kindly appreciate that. I'm giving an example. Mr. X is a reserve category. Mr. Y is general category. By virtue of roster, X becomes an assistant executive engineer prior to Y. Y, in the meanwhile, as long as X was assistant executive engineer, he also earns a promotion and he reaches the cadre of assistant executive engineer. So by application of the principle of catch-up rule, the general category candidate will become senior. Supposing in a given case, my lord, X from assistant executive engineer, he has traveled to executive engineer. At that stage, Y did not catch up. Then I cannot, then the general category cannot catch him.
Correct.
Is he trying to portray a case of that? If not, then what? Which is that example of merit, my lord? A mere argument in vacuum will not do. Which is that argument? Which is the facts you have pleaded? That this is the case, this is how my merit has been discarded. Which is that example, my lord? You can't make arguments in vacuum. Where are the arguments? Where are the material facts? You must come with empirical facts. That yes, I became so-and-so. Before the general category candidate came, I already earned a promotion to executive engineer. Therefore, Y cannot catch me up in the cadre of assistant executive engineer. I can appreciate. But that is not the case here. When you are speaking of cadre, when you join the cadre, did you compete with the others? Never. Well, the argument, yes, if there is an act, if there is a statutory provision, well, even my lord, in Indra Sawhney's case, Supreme Court says that reservation can be effected even by executive instruction. By invoking power under 162 also, that power can be invoked. Exercised. Now, question is, you are relying upon that judgment that, yes, if there is, then there you have enforceable right. When state has filed affidavit saying we don't have, state has issued two notifications, OM, one of 3/8/16, other of 18/123. What is the scope of countenancing the argument of the other side? My lord, these are very important aspects, my lord. Now, para 45, my learned friend, how can he say that it is in his favor? If it is in his favor, then it's well and good. If your lordship finds that para 45 also, has upheld what has been said by the learned single judge, then perhaps, my lord, the writ petition should be allowed. If not, then the writ petition has to be dismissed. So therefore, my lord, in the final analysis, going by the preponderance of the judicial view, my lord, the Honorable Supreme Court had never supported reservation, my lord, in the sense, excessive reservation and, my lord, accelerated seniority concept Supreme Court has never accepted. It is always, once there is a judgment, there is a constitutional amendment. Eventually, my lord, things settle after, my lord, the 2006 case, Nagraj. My lord, Jarnail Singh's dicta has been followed. If Jarnail Singh's dicta has not been followed, come up with an example. We'll rebut that. Where is that example? That dicta in Jarnail has not been followed. Where is that example? Then we'll file affidavit saying that you were wrong. Have you pleaded that? So, my lord, therefore, argument in vacuum will not do. Therefore, it's a clear-cut case. 12/3/2002 on which they are harping. It has its own operational value. Now it ceased to exist. At least with effect from 3/8/16 and reaffirmed by 18/123. That's my humble submission.
My lord, the points which I referred, I am giving the. In fact, last, my lord, 1 minute. The Assam government, in their affidavit, lordship will find it, WPC 363 has supported our case curiously by saying that the promotion has to be cadre wise, not group wise. In terms of journal. So possibly that officer might have gone through journalising and have become little bit,
We'll look into it.
yes.
Yes, heard, reserve.
Public.
This will, your arguments will cover which items? These
My lord,
arguments-
item 6 and 17.
No. Your item is separate. I'm talking
Yes.
about.
According to him, separate. According to me, it is within the series, my lord. My lord, what happened, my lord?
We'll hear you. First, let
Fine.
us have the
My lord,
matters in which.
what
he's
has
appearing.
happened? Lordship, on the last occasion I made that item number is this OM challenge will cover. My lord, the number 19, it will cover 9 items.
Item 1.
Yes, it will cover 9, 10.
No, item 1
My
is
lord,
the
Yes,
primary.
my lord, the
petition
main
you are
challenge
giving.
is item 1. Once the
Yes.
lordship gives the judgment, it will cover basically 1. So we cover number 9, it will cover. Number 10, it will cover. Number 11, it will cover. 12, it will cover till 12 lordship, then 12, 15 and 16 it will cover. The rest lordship, on the last occasion I made a prayer. The rest has to be, we want an implementation of the first judgment because the numbers which I'll give, there the selection was to a challenge of OM of 2016. It's not the OM of 2023. So there consequential orders has to be made in terms of the single judges.
These writ petitions were filed when?
My lord,
Item
this
num-
is basically item number 13.
No, say item number 2. Item 2.
My lord, 2 is earlier OM.
So let us have a look at item 2.
Yes. There, my lord, the police department, they didn't give us the benefit of consequential seniority. We wanted a gradation list to be corrected. And there was a judicial order also. There was some- promoted আমার দুটা পার্টি প্রমোশন these matters may come up on another date since your lordship is already tired. I don't want to trouble your lordship, so we can sort it out on that day.
Do I look tired?
No,
Then how did you know? I did not express anything. And we had a little extended break because of the
yes.
arguments. It is like this. Perhaps most of the members of the bars will recollect a situation when there were no ACs in the bar rooms.
Yes.
So in the middle of the summer with black coat and the glow,
Torture.
somebody asks you, don't you feel hot? And then you realize, oh, I'm supposed to feel hot now. So it's a query like this. If you say I'm tired, then I have to think, oh, am I tired? Or am I supposed to look tired? So yes. Item number 2, what is your prayer?
My prayer is simple, in terms of our entire case was that the benefits of consequential seniority was not given in the gradation list. And whereas some benefits were given to some reserve, similar situated reserve. This was a little bit different from it. So we wanted that since the lordship, in terms of
This is compliance with the order of Bhagavan Patrol.
No. We didn't come compliance of Bhavan Power. Basically, we brought in here, but our case was that we were not given the actual position. We didn't know what our position were in the gradation list. So we came on the first occasion and there was a judgment of Honorable Justice Pathak also for there was a direction. In the light of consequential seniority, the direction was passed on page 107. On 27/1/2020. We had come earlier also. So that order was also not complied with. In fact, Lordship will find the operative part at page 108. Further, it is submitted that the claims and objection. Page 108. Lordship.
Yes.
Further, it is submitted that the claims and objections regarding the draft gradation list under consideration where views of the personnel was also sought. It is observed the respondent in the Home Department shall consider the claim of the petitioner and others regarding their position in the gradation list for their promotion to the next higher post. The respondent in the Home Department only after following the law laid down by the apex court and the relevant rules, as well as laws and rules for promotion of person belonging to the reserve as applicable in force shall place the incumbent according in the including the petitioner and the gradation list for promotion to the higher level. The respondent shall complete the exercise between 30/4/2020.
So essentially, this will also be governed by whatever we hold in 363.
Yes, basically now. Because that was the spanner.
All right. Now, item 8 and 9, is it? What is that item?
9 and
6 and 17.
6 and
7.
6 and 17.
17.
My lord, in 17, my lord, they have not filed their affidavit. Neither the government nor the
6 and
Respondent,
17.
we have filed our
You
remedy.
want it on some other date, 6 and
Yes,
7.
well, that may be taken also. Because
and
my
17
agency is
want
that
to-
because of the injunction, my promotion is stalled for
kindly,
1 year.
kindly. I am the petitioner, kindly. My lord, in this case, what is my stand is clause 4.
No, he
So-
was
Yeah.
submitting that it may be taken up on some other date. So if you agree, we take it
Yes,
up on a
It will be better.
Thursday or some other date.
My lord, Thursday, because
Without
my
in-
agency is that the promotion is stalled because of the interim order. I
Yes.
filed a vacating application for 1 year, it was not.
Yes, my lord,
It was pending before
because I
Honorable
have a
Justice.
case, my lord, that's why promotion of reservation
Have you
has been
filed your
stayed.
objections to the IA? Objections have been filed.
My lord, we had filed our objections also. We have filed.
Now,
a
whose
vacating-
affidavit is awaited?
The tax department,
Tax department,
because they will also support me because my promotion is stalled.
Who's for the tax department?
Mr. Gogoi was there.
Buddha Google. And item 23, item 17, he has not filed anything, my lord.
This thing, we have filed in 3565
Let it,
also we have
let it
filed.
come on 22nd.
Yes, Lord.
22nd, is it?
My lord, on 22nd, we have another matter fixed that in the division bench, my lord. Same reservation, my lord.
Then on 27th?
Yes, Lord. My anxiety is that the stay order, I'm not being proposed.
My lord, I have a case, that's why stay order has been granted by your lordship, my lord.
27th February,
20?
7th, 27th.
27, yes, my lord.
Yes, please. 28.
Kundu.
But can it be on 28? Lord?
27 February.
Yes.
Item number 6 and
17.
17.
17 to be listed separately. Oh,
My lord, what I pray, my lord, these two items may not be segregated.
no, if it is not segregated, then
It
we
has to
will
be
hear it.
segregated. No, he
We have-
wants
we
that
have
it will
heard-
be tracked down.
All right, we have heard, all right, insofar as item number 1 is concerned, and is there any other item you're appearing, Mr. Chaudhary? Only item 1. So item 1 is concerned, the arguments are complete.
Yes.
The rest of the councils, we'll keep it on 27th. If there is any other
Yes,
council
yes,
who
why
wants
not?
to argue, you
Yes,
can
Yes,
place it
That will be better.
for further hearing in other writ petitions, connected writ petitions on 27th of February. And then you write, arguments in respect of WPC 363 has been concluded by the respective councillors.
Well, not only one thing I like to say, one will also connect 9.
You give the list, you give the
Yes,
list.
we will give the
You
list.
supply
We
the
have given
list.
the list.
Yes, you supply the list. Thank you. Anything more?
There's one next matter, my lord.
Okay.
Or Lordship wants to have it on some other day.
No, we can have it today. এখানে রাখি দিও তো। Yes, পানপুর আছে না, এই পানপুর গুলি কর।
ভবনে আমার হ্যাঁ My lord, my lord, what I feel,
Yes.
I'll take about half an hour. I think my learned friend would also like to reply.
Yes, my lord.
So today it may not be over.
My lord, will may take up
Thursday কি বার?
22 তারিখ?
Thursday?
Yes, my lord. 22nd, my lord can have, my lord. We'll get some time to conclude at least.
হ্যাঁ? 22 তারিখে না থাকে। রাখুন না থাকে।
He's for the principal. So.
But in
you
fact,
do
I
not
haven't
allege-
addressed anything
he's
on
not
Mela
allege
Fede.
malice. So you remain, if reply is required, you'll come and reply.
Yes, my lord.
Let it be on 22nd.
22nd.
22nd. Yes, Mr. Chaudhary on 22nd. Your deputy will be present. Because essentially,
Basically,
he has not urged anything against
Urge the allegation.
anything.
I'll
So
produce
we'll,
the
we'll,
record.
we'll give you another date for a reply if you want.
I'll produce the record, my lord. I'll demonstrate what we have done.
Fine.
Okay.
The heated argument.
My lord, I was just asking my senior what happened to this glass. my
This is
lord.
the fallout of the argument.
Some heat was generated, that's why.
This is the fallout of the argument.
That's right. Much of repeal.
It has given the registry a good reason now to remove it. Yes. The registration.
Yes, my lord, on the last two occasion, my lord, they not for time.
Somebody was required to inform us what is the status of
My lord,
the notification.
some notifications are required to be produced.
Yes, my lord, I'll produce that.
You have a copy with you?
Yes,
You have a
my lord.
copy with you? Can you read, please? 30th October 2007.
2007, yes, my lord. Prevention of,
What
Prohibition of Child Marriage Act. It was done to all, in
No,
respect of all the states.
Can you read the
Yes, my lord, I'll read it out. SO 1850E. In exercise of the powers conferred by subsection 3 of section 1 of the Prohibition of Child Marriage Act 2006, bracket 6 of 2007, Central Government hereby appoints the first day of November 2007 as the date for which the said act shall come into force.
No, but I think the query which he raised was, is it in force in Assam?
It is, my lord, because this, it is the central government who has to make the notification, who has to issue the notification under the provisions of the act. Section 1, subsection 3. It shall come into force on such date as the central government may by notification in the official gazette appoint. And different dates may be appointed. It is the central government who will. It was done blanket for all the states, my lord. Well, the first matter perhaps. And well, the second matter,
You are referring to which clause that it requires
My lord.
separate
My
notification?
lord, section 1, subsection 3, my lord, if I read over, my lord.
Section 1.
1 subsection 3, my lord. It shall come into force on such day as the central government may, by notification in the official gazette, appoint, and different dates may be appointed for the different states. And any reference in any provision of the commencement of this act shall be constituted in relation to any state as a reference to the coming into force of that provision in that state.
So for a state, the liberty is given to bring a separate notification.
My lord.
But that is not mandatory that it has to be brought. They
No,
can
my lord.
rely on the central government notification.
No, my lord, the central government notification, my lord, may kindly say
It
that
sh-
the
It
in
shall come into
exercise of
force.
the power conferred in subsection 3 of section 2,
Uh,
subsection 3 of the Prohibition of Child Marriage Act,
uh,
so and so the central government hereby
Appoints.
appoints the
appoints
first day of November 2007.
2015 in the date which the shall
Said
come
act shall
into-
come into
shall-
Comes
the
into
said act
force.
come into force.
Comes into force.
No, my lord, the statute is very clear, my lord. The
No.
central government is required to appoint different dates for the different state, my lord.
No.
My lord, may kindly see the language, my lord. The central
Different
government
dates
may.
May be
May,
appointed.
that is correct, my lord, may.
May.
But it has not said that as a one notification, it will have to apply for the whole country. my
Because
lord.
this is under list 3.
Subsection 3 says, my lord, that this it shall come into force on such day as the central government may by notification in the official gazette. If my lord says that the by notification in the official gazette, they will issue one notification for the whole state, then my lord, my contention will not
No,
survive.
from
But thereafter, my lord,
no, from subsection 3, how can you say
my lord.
that it requires separate notification for state?
Here-
It says that
thereafter, my lord.
that option is there.
No, my lord.
State may issue a separate notification.
No, state is not
No,
required, my lord. The
it's not that.
central government.
All
will
right,
issue
separate, central government may issue separate
separate
notification.
notification. That has not been done for the state of Assam, my lord.
No, may issue.
No, my
It
lord.
may decide that for this particular state, will issue a separate date.
My lord, the language, my lord, from my
Hmm.
limited understanding, my lord, what I have understand, my lord, that the it shall come into force on such day as the central government may, by notification in the official gazette, appoint, and different dates may be appointed for the different states, and any reference here is.
Now,
no-
let us cut short this and understand this in
My lord.
two compartments. Let us say the second part is not there.
My lord.
What was
But the
the
first part-
implication? What is the implication of the first
No,
First sentence?
First part, my lord, cannot be read in isolation, my lord.
No. What is the purport of the first part? If different dates will have to be given,
My lord.
then the central government will issue different notification.
Definitely, my lord.
Then why a single notification is required to be issued in the first place
That
at all?
That single notification is not in conformity with section 3, subsection 3, my lord.
Mr.
My lord, may kindly read
See,
over
the
the.
problem is if you don't want to read into the act, then it is difficult to carry on with your submissions. You see, you read the provisions of the Act 313.
My lord.
The opening lines are the central government by notification in the official gazette. So what is the purport of giving mandate of the legislation to give the power to the central government? If it is also the mandate of the legislation to ensure that for different states there will be different notification, then for whose benefit or whose implementation the central government is required to issue the notification in the first part?
My lord, the first part notification, my lord.
Then it becomes a conflict.
No, my lord, the state is not required to make a separate notification.
Not state, the
My-
center.
My lord.
Your argument is for state of Assam, there has to be a separate notification. That's your argument?
That's my argument basing on this provision. my lord.
That means for not only state of Assam, for all different states, there has to be a separate notification.
Exactly, my lord.
Right.
That is the
Then
purpose.
tell us what is the implication of the first line?
My lord, first part cannot be read in isolation, my lord. My respectful submission before my lord.
No,
is
sorry,
that-
sorry. Prima facie, we can't agree with your submissions unless you have some material to submit.
My lord, I will try to satisfy my lord the next day. Then even then, my lord, if we go by
So
this
before you
notification-
satisfy me, you have to satisfy yourself. On what basis are you making this argument? That this particular section
My lord.
has to be read in two parts.
No, I am not, I am not,
One supporting the other.
my lord, I am not saying that it should be read in the two parts, my lord, that the gazette notification which are required to be issued. My lord, the central government can, as a stroke of a pen, can issue that this is the date for the state of Assam, this is the date for the state of
See,
West
the
Bengal.
language is,
My lord,
it is not that central government will issue notification and official gazette for on different dates for different state. That is not the language in the act. The language in the act is central government will issue notification in the official gazette and appoint, and different dates
Maybe.
may be issued for different states. That's all. So there are options to issue one notification or several notifications.
first part is also starts with May, my lord.
This may has been quantified by this
Correct, my lord.
notification.
But for the rest of the part, they have not followed, my lord.
No,
That is also mandatory, my lord.
no, that means you are trying to say this may has to be read as shall.
Because the first part is also May, my lord.
Don't make arguments like this. Don't make arguments like this.
My lord,
You are interpreting an act.
my lord.
Your understanding, my understanding is irrelevant.
No,
You have to,
no, my lord,
find out what was the intent of the legislature.
No, my lord, my understanding before my lordship has no value, my lord.
It's not that.
My lord,
You are making an argument
My-
to interpret the intention of the
My-
legislature
my-
on
my-
what basis?
basing on the, my lord, provisions of this subsection 3, my lord. So, my lord, I will try, even then, my lord, if we admit that this notification will cover in the state of Assam, my lord.
Don't see, we
My-
have a whole list waiting. Don't waste judicial time. If you're not ready, come and
No, my lord, I have already argued my case on the merit also, my lord, on the last occasion, my lord, when this issue come. Then only, my lord, your lordship wanted to go through the. on
we
my
are
submission.
if you want, we are inclined to give you opportunity. If you say you have completed your arguments, we'll close the hearing.
No, my lord, they have not completed their reply, my lord, and if they completed their reply, then.
Once it is notified, that
My
is the end of the story. Your argument
Absolutely.
was it was not there.
No,
The
no, my lord,
notification required was not there.
My lord, my argument on the.
Your
on the-
notification, your argument was
My-
that in terms of 1(3), the central government or the state government will have to, or the central government, as you say now, will have to issue a separate notification bringing this act.
My
It
lord,
is there.
My lord,
Now you are saying
My
that
lord.
no, this one notification will not do. There has to be a separate notification for Assam by the central government.
My lord, that is my one limb of argument which my lord can reject, my lord. But on the merit of the case, which I have argued is on different footing, my lord. My lord, they have said that the Child Marriage Prohibition Act is a bar for the registration of a
You are
marriage.
not challenging the virus.
My lord.
You are not challenging the virus.
No, my lord has already, because I am not required to challenge the virus, my lord, because the Act of 1935 has empowered me, my lord can recall.
Therefore,
My-
it's a question of understanding which act will prevail.
Yeah, exactly, my lord.
So
Exactly, my lord.
this is an issue to be decided in terms of the rules of the High Court before a division bench.
And my lord can remand it, my lord.
We can't remand it.
My lord.
We can say if you press for this interpretation, then it has to be placed before the division bench.
No, my lord, we are not challenging the virus of any act, my lord. We
You
are
are asking,
challenging.
for interpretation
No, my lord, we are challenging the suspension.
between a central act and a state act
Yes, my lord. They are
over the
saying-
same area.
My lord, they are saying that the Child Marriage Prohibition Act being a central act
Hmm.
will override the
Yes.
1935 Act. Now, in the 1935 Act, my lord, I have already submitted before my lordship is that there is a provision in the 1935 Act that they have empowered me to register the minors Muslim marriages also. My lord.
Which is why we wanted to find out what happened to that, what is that authority before whom their application was placed.
My lord. The standing committee, my lord.
Standing
My
committee,
lord.
what has happened to that?
That, my lord, the information that I had that received this morning. It has not been placed, my lord. I'll place that.
Not been placed before the committee itself.
I'll place that, madam, the instruction that I have. It says, as regards placing of matter of order dated 21/6/23 before the permanent committee, it may be stated here that at present there is no permanent committee which is existent. And after expiry of term of previous committee on 28/10/21, as soon as the government notifies the permanent committee, matter will be placed.
Who notifies the permanent committee?
This is the Inspector General of Registration, madam. 1935, permanent committee, rules of,
You do one thing, you bring all this on record. The notification and whatever was placed or not placed.
yes, madam.
Because we were trying to explore whether if the permanent committee is there, the order of the, what is that? The
Suspension order.
suspension order is still, it is before a permanent committee, isn't it?
My lord, my
Yes,
So therefore, we wanted to find out what is the
lord. Exact situation.
state of the permanent committee.
Yes.
If there's no committee, then this order carries no meaning.
My lord.
Look at the order at page 50. Last paragraph.
3834. 3834.
3834. Yes, madam. But my lord, about the aspect between the two acts, my lord, what my learned senior colleague, Mr. Mazumdar, on the last date had placed. Well, like paragraph 13 of the 1995 4 SCC 104 judgment. Lordship has a copy of that, my lord?
We have,
Yes,
but whether under the rules we are required to give a finding by single bench or by division bench.
That, my lord, he has not questioned the
It is open
virus of
for,
the
it
act.
is for open to you to address the court. If you say it is possible, we can do
My
it.
lord, I have only questioned the suspension order, which is
But, my lord, it
unauthorized. and
stands
they cannot issue.
impliedly repealed, my lord, this.
No, 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 no. It is not like that. Means I have
You first file it on your, bring it on your record because
My-
These,
Mr. Bhuya says that it is not just this notification, there has to be a separate notification for Assam.
yes,
That's his primary contention, isn't it?
My lord, my lord.
So you bring it on record.
I
If
shall
he may
bring
like
this on
to say something on that.
Yes.
Heard learned counsel for the parties, Mr. M.S.S. Sharma, learned government advocate, has placed before the court a notification dated
30th of October,
30th of October
2007.
2007, issued by the Government of
Ministry
India,
of Women.
Ministry,
Women and
Ministry
Child
of Women and Child Development, Government of India, notifying the effective date
Jan,
of the Prohibition of Child Marriage Act 2006. Stop. Par contra, Mr. Bhuya submits that mere issuance of notification by the Government of India will not satisfy the provisions of Section 1(3) of the Act of 2006. He submits that under the provisions of Section 1(3), there has to be separate notifications for different states. And as far as Assam is concerned, no such notification has been separately issued by the Government of India. Stop. Under such circumstances, it is submitted that since his license was issued under the Act of 1935,
My lord.
what is that name of the act?
My lord, the
Assam
Muslim
Muslim
Marriages and Divorce
Assam
Registration
Muslim
Act.
Marriages and Divorce Act 1935,
Divorce Registration Act.
Registration Act 1935. The said license is valid and the provisions of the Assam Child Marriage Act 2006 cannot override the rights of the petitioner,
Right.
which have been
And-
granted under the Act of 1935. Since the questions of repugnancy has been raised before this court, the repugnancy of the Act of 2006 vis-a-vis the Act of 1935 has been raised before this court. At this stage, let the respondents file a detailed affidavit in response to the pleadings, in response to the averments made in the writ petition, and also bring the notification and any other relevant documents. Bring the gazette notification and any other relevant documents, if so advised, on record by way of the affidavit.
Right.
Let the matter be listed after 3 weeks.
Lordship, if a date may be fixed.
No, you file the affidavit.
Beg your
They-
lordship.
You file your affidavit, thereafter we'll fix a date.
Very well.
Let the affidavit be filed first.
My lord, interim orders may kindly be.
Interim orders passed will continue until further orders.
Fine. File your place.
May I please your lordship? My lord, instructions from the respondent corporation has been received.
Hmm.
I just seek some time, lordship, to file my affidavit.
Mr. A. Sharma, learned standing counsel, NEPCO, submits that he has received certain instructions in the matter from the department and would like to file an affidavit. MSA Gayan, learned counsel for the petitioner, does not object. Matter be listed after 2 weeks.
Yes. Obliged.
This will keep it for, this is that to be disposed of, isn't it? Thursday? We'll keep it on Thursday.
Problem, my examination of my son, his argument is completed.
Arguments are completed. We are only dictating the order.
Then I will place one judgment, my lord.
No, the arguments are complete.
One,
You may request your colleague to be present.
one,
Last occasion, Lordship had asked me to produce the record. Just once
Record
again,
report is-
to show. I'll just show the record once regarding the services, who has done how much.
That I think you have shown last time.
and one,
Yeah.
then one judgment I will place, my lord.
You place it on Thursday. You
Thursday,
ask
my lord,
your,
lordship.
or which date is convenient for you?
My lord, any date, my lord, except my lord. 22nd. 22nd day is exam, my lord. 27th.
29th.
First.
29th.
First.
27th, that series is fixed,
Obliged.
so it will make no difference. Yes.
Here.
Lord, these matters are relating to retrospective revision of variable dearness allowance, Lord.
Hmm.
If your lordship may come to the last order passed in writ petition 5752/21, my lord.
5752.
Lord, it's item 24. Lord, it was fixed on 5th of February.
5752.
Lord, in
Yes.
this matter, the respondent number 4, they have filed their affidavit in opposition.
Hmm.
Lord, the matter was ought to have been fixed on 1st of April, my lord.
Okay.
My lord, all the matters may be fixed together and we may be allowed to file a reply. In the other matters, they have not filed their reply affidavit.
As
at all.
per the earlier order dated 5/2/2024, passed in WPC 5752 of 2021, the matters were directed to be listed on 1st of April 2024. And the interim order was directed to be continue, was directed to continue till the next date fixed. The petitioners were also given liberty to file a reply affidavit to the affidavit in opposition filed by the respondents. Accordingly, registry to list this writ petition along with the other WPC so and so on 1st of April 2024. Respondents may exchange their pleadings in the meantime. Interim orders, if any, will continue to the next stage fixed. Yes.
The issue is very small and simple. Lord, what happened in this matter? The petitioners, they are retired PCCF and HOF. They retired in the epic scale. The government of Assam, my lord, issued an office memorandum by virtue of a cabinet decision saying that these officers who are in the rank of chief secretary and equivalent will be entitled to have one telephone and security assistant. And the mode of appointment is that the officer has to recommend one person and government will approve that, and whatever the expenses, those will be paid by the government. Now, initially, you know, the petitioner, number one, he engaged one Manjula Das as his telephone and security assistant. She was continued to be paid by the government. In the interim, Milord, for some difficulties, the said Manjula Das left and he wanted to engage another person. At this juncture, Milord, the government has come up with a stand that you are not entitled. I'll just take your lordships with the office memorandum. Which contain the decision.
Yes.
Page annexure P2, page 21 is the first office memorandum. If I may read, Milord, subject creation of a post of telephone and security assistant with fixed pay for retired chief secretary and equivalent rank. The governor of Assam, after due consideration, is pleased to decide that the officers retiring from the post of chief secretary and equivalent rank who retired from government of Assam and who has permanently settled within the state of Assam may be provided with the facility of the services of one telephone and security assistant for discharging duties like attending telephone calls, etc. in the residences of the officers concerned. The assistant shall be entitled to pay to a fixed pay of 4,500 only per month. The entitled officer may recommend a suitable person of his or her choice as the telephone and security assistant to the Secretariat Administration Department. According to the person shall be born outside the regular cadre of grade 4 staff. The expenditure of this account will be debitable to the head of account so and so so and so. The terms and conditions under which the appointment is to be made as detailed above should be strictly adhered to. This has the approval of state cabinet. So pursuant to a cabinet decision, this was taken. Initially, it was confined to the officers who resides within the state of Assam. Thereafter, they have issued another notification, page 22. It says extension of facility of the telephone and security assistant with fixed pay for the retired chief secretary and equivalent rank settled outside Assam also. So by this, the benefit was provided to officers in the rank of chief secretary and equivalent who are stationed outside Assam after their retirement, my lord. This also pursuant to cabinet decision, my lord. Then page 23 is the appointment of telephone and security assistant, Sri Manjula Das, in pursuance to office order dated read with so-and-so, Sri so-and-so is hereby engaged in telephone and security assistant on ad hoc basis as consolidated pay as per department's OM issued from time to time attached to Sri D. Mathur, formal PCCF and HOF with effect from 1/1/2020 on the subject following terms and conditions. Number one, the post against which he is appointed shall be treated as ex-cadre post, not being a part of the regular grade 4 in the secretariat. His service is purely temporary ad hoc and subject to termination at any time without notice and until further orders. Number three, the appointment does not confer any right whatsoever to be considered for regular grade 4 cadre in secretariat. However, the appointee may apply for such post to be considered as per existing rule and procedure prescribed for the purpose. Now, she was initially appointed
as telephone and security assistant of petitioner number 1, my lord. Then my lord will kindly come. Page 26, my lord, I have given the type copy.
Then she was replaced.
She was replaced, that she, for some personal reasons, she did not want to continue. Then the petitioner number 1, he said that another recommended the name of another person. The respondent sat over the matter. Now they come up with a stand that the chief secretary and equivalent doesn't mean that it includes PCCF and HOP also. They say chief secretary and equivalent means only chief secretary. The apex scale has got nothing to do herein. And there are instances, Millard, I have given examples wherein additional chief secretaries are also given the benefit of this telephone and security assistant. Additional chief secretary is also not a chief secretary. If that analogy goes, then how can you give to them and restrict these persons, Millard? 3 wings are there, Millard: police, civil service, and forest, Millard. Article 302, 312, Millard, creates these 3 wings, Millard. You cannot discriminate in between these wings by this manner, Millard. That is precisely the case. Page 27 is my representation that I recommended one Rajesh Deuri on 9/11.
What is an equivalent rank?
Milord, the equivalent rank has to be understood from the scale of pay, level 17. That is the apex scale. 2,25,000. Beyond that, there is nothing. Chief Secretary is given that particular pay scale. The PCCF HOF is given that particular pay scale. Additional Chief Secretary who reach that scale are given the benefits. Those I have annexed, Milord.
Yes.
If your lordships kindly see the equivalence, page 30, they themselves have said, this is a notification giving promotion in the interest of public services so and so. Now, on central deputation, Government of India is allowed to allow pro forma promotion to apex scale level 17 of pay matrix so and so, 2,25,000 fixed per month within bracket Chief Secretary grade with immediate effect. There is another person, Sri Vijayendra, IS, Principal Secretary of the Government of Assam Handloom and Textile Department, allowed to officiate in the apex scale level 17 pay matrix, 2,25,000 per month, Chief Secretary grade, posted at Additional Chief Secretary of the Government of Assam Handloom and Textile Department. So there are instances, Milord, I have given in my reply. If my affidavit in reply is taken by your lordships.
No, first, let us go through the affidavit filed by the respondent.
Yes, Milord. They say.
It does not to the apex scale of pay.
They say in para 4, that with regard to the statement made in para 5 of the writ petition, the answering deponent respectfully begs to state that after partial modification of the earlier OM dated so and so, the service of telephone and security assistant is extended to the officers retiring from the post of Chief Secretary and equivalent rank who retired from Government of Assam and settled outside Assam also, right? Office memorandum dated so and so. It may be stated that as per the office memorandum, the facility of telephone and security assistant is provided to the retired Chief Secretary and equivalent rank, but not to the apex scale of pay. Now, how can you determine the equivalence if you don't rely on apex scale? Then you should have written in the office memorandum that only to Chief Secretary, not equivalent rank. Equivalence can only be determined from the pay scale. This PCCF of is the highest post in Forest Department. Now, further they say in page 34, it may be mentioned here that there was ambiguity between equivalence of apex scale to that of officers retiring from the rank of Chief Secretary and equivalent rank. The matter was subsequently referred to Finance EC3 for views. In accordance with the Finance EC3 clarification and in view of the Office Memorandum of General Administration Secretariat Nazrat Department dated so and so, subsequent appointments were not carried out. Now here there is a question, my lord. Both the two office memorandums, those were the decisions of the cabinet. It was pursuant to a cabinet decision. How can the finance department, my lord, poke their nose into it and take an unilateral decision? No, no, no. From now onwards, we are not giving, my lord. Can a cabinet decision can be interfered or alienated in that manner, my lord? Then para 7 they say,
So how many officers are there in the apex scale of pay?
in the apex scale of pay, my lord, every year, my lord, officers reach to that scale.
No, so
And-
it's
and-
not
and-
only restricted to PCCF,
No, not,
I mean Forest
no,
Department.
if PCCF, my lord, in the forest department, apex scale means a reasonable, I'm sorry.
Apex scale is it restricted only to the Forest Department? No.
No, no, no.
So across the board, across the department, there will be several officers.
Yes, yes.
So according to you, all these officers will have to be given that benefit
Yes.
who are in the rank
I'm
of.
giving that benefit. I have annexed in my reply, if your lordships kindly take up,
Hmm.
officers in the level of additional chief secretary who reach the apex scale, they are given. Page 50.
Additional is different. Any other
No,
departments?
additional chief secretary, since he is from civil service background, it will be additional chief secretary. In the forest department, it will be PCCF and HOP. We are concerned with the scale of the person that he is
Yes,
getting.
who's for the respondent?
My lord, in this regard, the affidavit has been filed on behalf of respondent number 2. That is the Secretary of the Administrative Department. Lordship may kindly turn to page 42. Running page number 42.
Yes.
There is a note sheet, my lord. As per the affidavit,
Hmm.
the Secretary Administrative Department, they moved the Finance Department for certain views. Now, page 42, the official note sheet of Finance Department. Lordship, may I read it, madam? Finance Department observes that OM dated 7th of April 2010, which provides for telephone and security assistant with fixed pay for retired chief secretary and equivalent rank, has been issued with the approval of the state cabinet. So also, administrative department may be pleased to place this proposal before the state cabinet for favor of perusal and necessary approval. It may be mentioned here that ex-PCCF and HOF cannot be an equivalent rank of chief secretary of the state because chief secretary is the exclusive position in the state. This has the approval of the secretary finance department.
Now, what is
Now,
the
in the
state?
present case, my lord,
Was
the
it-
finance is
was
not a
it
party.
placed?
No, finance is not a party, my lord.
No, was it placed before the authority? I mean, the cabinet again?
That instruction, my lord, perhaps is not there in this affidavit.
Finance is not a party.
No,
Then
apparently, my lord, this is the authority who has issued this, my lord.
When we filed the writ petition, my lord, we were not aware of this fact that they moved the
how
finance.
you know?
In January
Sorry.
23. this
How
has
you
been filed, my
know?
lord.
You are
Yes,
agree. You are agreed by this opinion at page 42.
Yes.
yes.
Then
Ought to have been made a party, my lord.
they should have been made a party.
Party, my lord. There is no difficulty in that. I'll make a party, my lord. I'll make them party, my lord. Whatever stand they want to place, but otherwise, the decision making
Decision
process.
is to be placed. It is to be placed before the cabinet.
If
That
you
is
want
what-
to, if you want to change the earlier office memorandum, you are to place before the cabinet, no way out. But they have unilaterally stopped it, my lord, by a decision of a joint secretary finance. That cannot be done, perhaps, in my respectful submission, my lord. So decision is before your lordships, whether finance is a party or not, my lord. The entire decision is before your lord.
No. Decision is there, but if you are agreed by this, you are agreed by this finding of the finance.
I can make a party.
You are agreed. If you are agreed, they are entitled to be put to notice.
I'll make them party, my lord. No problem in that.
At the request of Mr. H.K. Das, matter stands adjourned for 2 weeks, enabling him to file necessary applications for arraying Finance Department as a party is prayed for.
Right.
Mr. B. Gogoi and Mr. A. Fukan appears for the respondents.
My lord.
Yes.
Obliged.
The rest of the matters deferred.
My lord, item 32, my lord,
Suspension matter, my lord, 2 times listed, could not be reached, my lord. 1 year, my lord, suspension and suffering. Item 32, 27 or 29, my lord.
32.
32. Either 27 or 29, any date, my lord, convenient to your lordship.
22nd or 30th. Let it go to March. 7 March.
7 months.
Lordship, one prayer with regard to, I'm at item 31, my lord. It's a dismissal from service matter. If can be taken
Dates will be provided depending on the availability of,
5th or 7th, any date, my lord.
not like
March.
that, not like that.
Eviction series.
We are giving suspension because there are some matters which are fixed, so it can come up
Dismissal.
together.
Dismissal.
Dismissal from service will require examination of the record.
That's any date, hearing
So
date.
the
5 or
hearing
7.
date will admit and then hear it, you tell us.
There is some urgency, my lord.
Lordship,
The
that
person is
series with the
serving.
46 to 81, that TV hospital land, Lordship.
Ah.
We are led by the Advocate General, sir. Can it be on 27th, Lordship, next Tuesday?
No, 27 we have already booked that series is there, that's reservation matter.
Then, Lordship, then 29th, Lordship, Thursday.
29th or 30th. All right, 29th.
29th. Obliged, Lordship.
Can it be on 5 or 7, any date?
all right,
Inconvenient.
I must have difficulty on, maybe on 12th, either, 12th of March.
46
Item
to
31,
81,
I'm for the respondent.
29th.
The item is yet to be admitted.
All right, 12th of March.
Yes, my lord.
12th of March.
31.
12 is a
Our,
Monday.
that one is 29th series.
Wait, one by one, one by
Fine,
one.
fine, fine, ठीक है.
Series 46 to 81.
Ah, that is on
12,
29th. 29th.
Move में दिए थे भाई तो.
12.
No, please, your lord.
मेरा
My lord,
mood-
item 42, my lord. The pension matter, but
Obliged.
taken up it on 28, my lord.
All the other matters will go to March. Second week of March onwards.
May I please, your lordship, item number 40, 41. That may be fixed on,
Then, my lord, maybe
14th of
taken up
March.
it on 11. my lord.
Why?
because, we have some
What is the matter?
claim of some dues.
So let it come in March. It'll come in March.
With regard to item number 37 and 38, your lordship, the stay order is operating against us.
37, 38.
37 and 38, your lordship, on 11th of March, your lord. Or your lordship, then 19th of March.
12th? No,
12th, I have some difficulty, your lord.
19th. All right,
19th.
19th.
There is interim order, both that.
Interim order, so-and-so will continue till the next day.
Both that.
Item numbers
37 and 38. your lord.
37, 38.
I'm
Next on 19.
And a
Item-
petition, your lordship.
Item 42, maybe taken up it on, my lord, 12, my lord.
Item
42.
42 on 12th. Yes.
Item 43. Lordship has decided to pass an interim order to be fixed, lordship. So lordship may take it as per lordship's convenience. Lordship in February itself.
February is not possible.
Lordship,
Mr.
I did lordship, because lordship has fixed this. matter
What is the
twice.
matter about?
Lordship, the review of the suspension order, lordship. That is the lordship has taken an instruction, what is the stays? On 28, lordship. Only that point, Lordship. Only that point.
28,
Only that point, lordship. They will produce the record regarding review of the suspension
we
order.
can have it on 1st of March.
My lord, exactly similar, my lord, issue. Your lordship asked my lord to take the instruction whether.
1st of March.
My lord,
1st of March.
obliged.